crime in forfeiture of property under Section 17 of the Advance Fee and Other Related Offences Act. A civil forfeiture is a unique remedy which rests on the legal fiction that the property, not the owner, is the target. Therefore, it does not require conviction or even a criminal charge against the owner, as it is not a punishment nor is it for criminal purposes. See also the cases of Lawari Furnitures and Baths Limited versus Republic of Nigeria, Alison Madueke versus ESCC. From the legal definitions and judicial authorities cited above, it is clear that the sentence of imprisonment or fine for any offense involving dishonesty or fraud envisaged in Section 137 of Section 1D of the Constitution is one imposed upon a criminal trial and conviction. In the instant case, the petitioners have failed to show evidence that the second respondent was indicted or charged or arraigned, tried and convicted, and was sentenced to any term of imprisonment or fine for any particular offense. On the part of the second and third respondents, they have contended that the second respondent was never fined for any offense and has no criminal record in the United States. In proof of their assertion, they have tendered exhibits RA8 and RA9 from the bar and called RW2 to give evidence and identify the said exhibits as documents referred to in his adopted statement of oath on oath of 12 April 2023. In paragraph 45 to 52 of his statement on oath, RW2 has stated that the second respondent was never convicted or fined for any criminal offense in the United States as alleged by the petitioner. In particular, RW2 stated as follows in paragraph 46, 47, and 49. 46 says, in case number 93C4483 at the United States District Court, Northern State District of Illinois, Eastern Division, which was pleaded by the petitioners. 1. No criminal charge was filed against the second respondent. 2. The second respondent was not arraigned and did not take or make a plea to any count in the charge of allegations of crime. 3. The second respondent did not go through a criminal trial. 4. The second respondent was not convicted of any crime or any criminal activity. 5. No sentence of imprisonment was imposed on the second respondent. 6. No sentence of fine was imposed on the second respondent. 7. No form of sentence was imposed on the second respondent. 8. Case number 93C4483 was a civil suit in respect of which the court exercised civil jurisdiction under 18 U.S.C. 981 and 28 U.S.C. 1345 and 1355. In paragraph 47, he said, I also note that in case number 93C4483 at the United States District Court, Northern District of Illinois, Eastern Division, no impersonal criminal sentence was imposed on the second respondent. 49. The second respondent was not convicted in case number 93C4483, United States District Court, Northern District of Illinois. The United States of America, through its embassy in Nigeria, had, by a letter dated February 4, 2003, addressed to the then Inspector General of Police, confirmed that upon the record checks for the Federal Bureau of Investigations, National Crime Investigation Center, NCIC, centralized information center that maintains the record of every criminal arrest and conviction within the United States of America, there were no records of any form of criminal arrest, warrants against the second respondent. I shall rely upon a copy of the said letter of February 4. and which was later tendered in evidence at trial as Exhibit X1. The first respondent particularly referred this court to paragraph 55 and 74 of the petition and submitted that the facts alleging non-compliance to the Electoral Act, which are set out in paragraph 33 of the petition, are hinged on the same issue of electronic transmission of results, which was resolved against the second petitioner in the same suit number FHC ABSC 145 for 2022, to the effect that there is no mandatory requirement for the first respondent to electronically transmit results of the election. Lies was placed on Begin and others was Oriabe, Oye Roba, and others was Laupa. An examination of petitioner petition and Exhibit X1 shows that in their petition, specifically by the 3745 and 45, the petitioners have averred as follows. The petitioners averred at the point of the election and at each polling unit, the presiding officer was mandatorily required to electronically transmit or transfer the result of the polling unit directly to the collation system of the first respondent. In addition, the presiding officer was also mandatorily required to use the BVAS, upload a scanned copy of the Form EC8A to the first respondent's result viewing portal, IRF, real time. 5. The petitioners averred that apart from the importance of the BVAS in the capture of accreditation at polling unit in an election, the BVAS is also mandatorily used in the process of uploading the information or data imputed in it by the first respondent's presiding officer at each polling unit, who shall, upon completion of voting and due recording and announcement of result, 1. Electronically transmit the result of the polling unit directly to the collation system as described by the first respondent. 2. Use the BVAS, upload or a scanned copy of the Form EC8A, the annual result viewing portal area prescribed by the first respondent. And 3. Take the BVAS and the original copy of each of the forms, tamper evident envelope to the registration area or ward collection officer, the company of security agents. The polling agents may accompany the person to the registration area to ward collection. In Exhibit X1, the certified true copy of the judgment of the Federal High Court in suit number FHC ABJ CS 1454/2022 Super, which the first respondent is contending constitute estoppel. Ground 2 of this is as follows. Whether, having regards to combined effect of sections 47, 2, 52, 64, 65, and 62(1) and 2, and other relevant provisions of the Electoral Act 2022, the respondent can still insist on manual collection of results in the forthcoming general election. Upon determination of the above questions, the plaintiff, which is the second petitioner here, sought for the following reliefs. 1. A declaration that the respondent has no power to opt for manual method other than electronic method provided for by the relevant provisions of the Electoral Act. 2. An order of this honorable court directing or compelling the respondent to comply with the Electoral Act 22 and electronic transmission of results in the forthcoming general election. In its judgment in Exhibit X1, the Federal High Court held as follows. In view of the foregoing, can the act of the defendant in collecting and transferring election results manually in the forthcoming 2023 general election be said to be contrary to the relevant provisions of the Electoral Act 2022? The answer can only be in the negative, as there is nowhere in the above cited sections where the Commission or any of its agents is mandated to only use an electronic means in collecting or transferring of election results. If any, the Commission is only mandated to collect and transfer election results and number of accredited voters in a way or manner deemed by it. In view of the above, I'm finding that by the provision of sections 52 and 65 of the Electoral Act 2022, the correct interpretation of said statute is that the defendant, Independent National Electoral Commission, is at liberty to prescribe the manner in which election results will be transmitted and so forth. Consequently, this matter is hereby dismissed. Close of court. It is third law that for a judgment of a court to conclude estoppel in a subsequent action, it must have finally decided the same issue in contention between the same parties or their previous. The Anchorage Leisures Limited and others was Eco Bank Limited. And Adebayo versus Babalola and others. From the averments contained in the petitioner's petition, which I have earlier reproduced above, it is clear that the petitioner allegation of non-compliance averred in paragraph 2 of the petition is hinged on the contention that ANIC was mandatorily required to electronically transmit or transfer results of the polling units directly to the collation system, the first respondent, and also mandatorily required to use the BVAS, upload a scanned copy of the Form EC8A, the first respondent result viewing portal, RF, real time. Thus, it is evident that in both this petition and in Exhibit X1, the parties are the same. In that second petitioner herein was the sole petitioner plaintiff in Exhibit X1, while the first respondent herein was the sole defendant in Exhibit X1. Secondly, from the above referred averments in this petition and the relief sought by the petitioner in Exhibit X1, it is clear that the issue in both cases is whether the first respondent herein mandatorily required to electronically transmit or transfer election results from the polling unit direct to the collation system, which has been reproduced above. It is evident that the Federal High Court had decided the issue against the petitioners by holding that the first respondent cannot control the election result. There is no evidence before this court that the second petitioner against whom the judgment is X1 was given has appealed against that decision. It's settled law that an appeal decision of the court remains subsistent, binding on the parties. The Abba versus Abba Aji, Jegede and ANIC, Alexander and others versus Lone Star Drilling Company Limited. It is also tried that the doctrine of issue established is that while an issue has been decided by a competent court, the court will not allow it to be relegated by the same or different parties. It is also pertinent to the address of the first respondent. Our attention was drawn to the recent decision of the Lagos Division of this court in appeal number CA/LAG/332 of 2023, APC and Labour Party and 42 others, wherein this court set aside the decision in suit number APC/L/C/370/23, Labour Party and others versus ANIC. Another case from shopped by the second petitioner at the Lagos Division of the Federal High Court after losing at the Abuja Division of the same court in Exhibit X1. In the judgment in appeal number CALG-CV-332/2023, this court had upheld the decision of the Federal High Court in Exhibit X1 and construed same against the petitioners as issue estoppel in relation to the petitioner contention which they are making in this petition, that is that ANIC is mandatorily required to electronically transmit election results. By virtue of Section 122 of Section 2 of the Evidence Act, this court is entitled to take judicial notice of a decision in appeal number CALG-CV-332/2023, APC versus Labour Party and 42 others. Not only that, this court is by the doctrine of precedent bound by that decision. Since the above judicial pronouncements have decided that under the Electoral Act and the Administration Guidelines for the conduct of elections, the first respondent cannot be compelled to electronically transmit election results. The petitioners are clearly stopped by those decisions from contending in ground 2 of this petition that the first respondent is mandatorily required to electronically transmit the election results to the election system. As a court of first instance, in this petition, we shall, notwithstanding our above finding, proceed to determine the merit of ground 2 of the petition relating to non-compliance. It is observed that in their petition, the petitioners have alleged the same set of facts in paragraph 33 to subnet concerning non-compliance corrupt practice. On a careful perusal of the petition, however, it seemed to us that the allegations of non-compliance are contained in part 33 to 56 and 59 of the petition, while specific allegations of corrupt practices were made in paragraph 60 to 78, even though they were founded with the same facts, non-compliance alleged by the petitioners. The gravamen of the petitioner allegations of non-compliance are as encapsulated in paragraphs 37, 45, 50, 51, and 55 of the petition, which are reproduced. Have produced. The respondents, particularly the first respondent, denied the allegations of non-compliance made by the petitioners in their respective replies to the petition. In particular, the first respondent denied that there was any collation system of the first respondent, which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer, and stated that the prescribed mode of collation of results is as stipulated in paragraph 50 to 55 of the regulations and guidelines for the conduct of elections. He further stated that the prescribed mode of collation was manual collation of the various forms EC8A, EC8B, EC8C, EC8D, and EC8E of the presidential election. See paragraph 31 of the first respondent's reply. He also stated that the BVAS is designed to upload the accreditation data at the end of the accreditation process and transmit the result of the election at the polling unit through the e-transmission system, which is uploaded to the first respondent's result viewing portal, IREF. The first respondent further averred that the upload of data or images captured and automatically restored on the device requires data service, and where there is no such data service, where the service is poor, the BVAS service is designed to work offline. The upload of data will occur when data service is available. He also stated that polling unit results were duly uploaded on the first respondent e-transmission system by the respective presiding officers at the end of the election, but some of the results were not visible on the IREF portal due to the technical glitch on the election day. The specific response to the petitioner's allegation of failure, refusal, and neglect to instantly transmit and upload the results electronically from the BVAS to the IREF. The first respondent stated in paragraph 55, the Romans 7 and 10 as follows. Immediately after the election of 26 February 2023, polling unit results were uploaded and received by the e-transmission system whilst using the BVAS. There was a temporary failure of communication between the e-transmission system and the IREF portal for the presidential election. In this regard, the e-transmission system returned an HTTP 500 error, which is an application error such that transmitted results, though received on the in-transmission application hosted on the AWS, the in-transmission did not organize and push the results instantly to the presidential module on the IREF portal because it could not map the results uploaded for the presidential election any state. The first respondent pleads I shall rely on the AWS CrowdTrail logs indicating patches deployed to fix the error of technical glitch on the election day. Upon resolution of the HTTP 500 error, the results which were delayed in the e-transmission system were eventually organized and pushed to the IREF portal. The results are available as generated in their original form from the polling unit using the BVAS. The first respondent stated that the technical glitch did not in any way affect the result of the presidential election. However, in paragraph 37 of their reply to the first respondent reply, the petitioners denied that there was any technical glitch experienced on election day as contended by the first respondent, and stated that the failure of the first respondent to adopt the presidential election results using the BVAS to the IREF was deployed to manipulate the actual results of the election. As indicated in their pleadings and submissions of counsel, the petitioners' allegation of non-compliance with the Electoral Act 2022 and the regulations and guidelines for the conduct of Election 22 is anchored on the provisions of sections 47(2), 61(2) and 5, 64(4)(a) and B, 64(5) and 73(2) of the Electoral Act, and paragraph 38(1) and 2, 48(a), B, C, 55, Roman 5, 7 and 20, 51(2), 54(12) and 55(12), 93 of the regulations and guidelines. I've carefully considered the submissions of parties on this issue of non-compliance with the Provisional Electoral Act and the paragraph of the regulations and guidelines for the conduct of the election 2022. The Independent National Electoral Commission, the first respondent hearing, is established by Section 153, subsection 1F of the Constitution of the Federal Republic of Nigeria 1999, and part of its functions are stated on paragraph 15 in Item F, Part 1 of the third schedule to the State Constitution, is to organize, undertake, and supervise elections, including election to the office of the President, Vice President, among other political officers listed. In a creation of the Constitution, INEC is empowered by Section 160, subsection 1 of the Constitution to make its own rules or otherwise regulate its own procedure, and in so doing, it shall not be under the control of the President. Indeed, by Section 158, subsection 1 of the Constitution, INEC shall not be subject of direction or control of any authority person. By Section 4 of the 1999 Constitution, the legislative powers of the Federal Republic of Nigeria is vested in the National Assembly, which in the exercise of that power has enacted the Electoral Act 2022 to regulate the conduct of elections in the federal, state, and area councils of the Federal Capital Territory. Section 47, subsection 2 of the Electoral Act, relied upon by the petitioners, mandates every presiding officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intended voter in the manner prescribed by the Commission. Also, under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of accredited voters and the results of the ballot, in a manner as prescribed by the Commission. Section 62 sub 1 of the Act specifically provides that after the recording and announcement of the result, the presiding officer shall deliver same along with election materials under scrutiny and security and accompanied by the candidates or their agents where available to such person as may be prescribed by the Commission. Further, Section 64(4) states that the collation officer or returning officer at an election shall collate and announce the results of an election subject to his or her verification and confirmation that a number of accredited voters stated on the collected vote are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under Section 47, subsection 2 of the Act. And B, the votes stated on the collected results are correct and consistent with the votes or results recorded and transmitted directly from the polling units under Section 60, subsection 4 of the Act. At this stage, it should be noted that Section 47, sub 2, referred to in Section 54(4)(a), relates to the procedure for accreditation of voters by the presiding officer using the technological device prescribed by the Commission. As for Section 64, referred to in Section 44(b) of the Act, it only mandates the presiding officer to count and announce the result at the polling unit. In fact, Section 5 of Section 60 goes ahead to mandate the presiding officer to transfer the results, including total number of accredited voters and the results of the ballot in a manner prescribed by the Commission. The Act also provides in Section 64(5) that the collation officer or returning officer shall use the number of accredited voters recorded and transmitted directly from polling units under Section 47(2) of the Act, and the votes or results recorded and transmitted directly from polling units under Section 64 of the Act to collect and announce the result of an election if the collected result at his or her lower level of collection is not correct. From the aforementioned sections, it is clear that while subsection 4 of Section 64 provides for what the collation or return officer will use to verify and collect the results. Subsection 5 also provides for what the collation or return officer will use to collect the results. Subsection 6 of the same section provides for what the collation or return officer will use to determine the correctness of the result where there is a dispute. These are A, the original of the disputed collected result for each polling unit where the election is disputed, which in our view means the physical or hard copy of the disputed result. B, the technological device used for accreditation of voters in each polling unit where the election is disputed. C, the data of accreditation recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 47 of Section 2 of the Act. And D, the votes and result of the election recorded and transmitted directly from each polling unit where the election is disputed and as prescribed under Section 64 sub 4 of the Act, which requires only the counting and announcement of the results polling unit. A careful examination of the above sections that opened by the petitioners show that the Electoral Act had used the words deliver, Section 62, subsection 1, transfer, Section 65, and transmitted directly in sections 50 sub 2, 4, 4, 5, and 6 of the Electoral Act 2022, in stating how results of election should be handled under those provisions. A look at the definitions of those words in the Black's Dictionary 6th edition shows that the word transfer is defined at page 1497 as to convey or remove from one place, person, etc. to another, or to pass or hand over from one to another, or to specifically to change over the possession or control. The word transmit, on the other hand, is defined by the same law dictionary, mean to send or transfer from one person to place to another or to communicate. In my view, the Electoral Act 2022 has used the words deliver, transfer, and transmitted directly, interchangeably, to describe how the results of the election shall be moved from one stage to another until the results are finally collected and declared. In all these, the Electoral Act 2022 has not specifically provided that the result of the election shall be electronically transmitted. It is in the exercise of its powers under Section 160 of Section 1 of the 1991 Constitution and Section 148 of the Electoral Act 2022 that the first one does annex herein made the regulations and guidelines for the conduct of elections 2022 as well as annex manual for election officials 2023. In paragraphs 14A and 18A of the regulations, the first respondent prescribed the bimodal vote accreditation system givers as the technological device for the purpose of accreditation and verification of voters in the 2023 general election. The petitioners have also hinged their allegation of non-compliance on the 38.1 and 2, 48A, B, C, 55 and 7 and 20, 51, 2, 54, 7, 55, 7, and 93 regulations and guidelines. Paragraph 38 of the regulation provides as follows. Extensive to get a copy of the guidelines to receive. Here we have produced it in this document. From the foregoing provisions of the regulations and guidelines relied upon by the petitioners, it is clearly evident to me that although the Electoral Act has provided in Section 62, subsection 1, for the delivery by the presiding officer of the result along with other election materials under security and accompanied by candidates or their polling agents where available, such a person as may be prescribed by the first respondent. The first respondent has, by paragraph 38 of the regulations and guidelines quoted above, introduced electronic transmission to a collation system in addition to the physical transfer of the election results to the registration area of vote collation officer. As stated earlier, the technological device as prescribed by ANI in the conduct of the 2022 election is the bimodal voter accreditation system, BVAS. The function of the BVAS, as stated in paragraph 14A and 18A, is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or her fingerprints or face facial recognition, thus accrediting the voter to vote at the election and storing the data and number of such accredited voters. By paragraph 38, 2 and 3 of the regulation, the BVAS is also to be used by the presiding officer to upload a scanned copy of the EC8A to the ANEC result viewing portal, IREF, after which the presiding officer shall take the BVAS and the original copy of each of the forms to the registration area toward election officer. From the above functions of the BVAS, it is clear to me that apart from using the BVAS to scan the physical copy of the polling unit results and upload same to the IREF, there is nothing in the regulation to show that the BVAS was meant to be used electronically transmit or transfer the result of the polling unit direct to collation system. It should be noted that the ANEC results being portal, RF, is not a collation system. The Supreme Court in Oyetola and ANEC 2023, ANEC 23 LP EILR, has explained the difference between the collation system and the IRF. In that case, I give JSC held as follows: court. As their names depict, the collation system and the ANEC result viewing portal are part of the collation process, the election process, and play particular roles in that process. The collation system is made of the centers where results are collected at various stages of the election. So the polling unit results transmitted to the collation system provides the relevant collation officer the means to verify a polling unit result as the need arises for the purpose of collation. The results transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results on the election day. The community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of elections 2022, and the ANEC Manual for Election Officials 2023 show that the Electoral Act provides in Section 62, subsection 1, that after recording an announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their polling agents to such persons as may be prescribed by the Commission. The regulations and guidelines, as well as the ANEC Manual, also state that hard copies of election results shall be used for the collation, and it is only where no such hard copies of the election results exist that electronically transmitted results or results from the IRF will be used to collect the results. The petitioners who contend that ANEC was mandatorily required to electronically transmit the election results to the collection system have called PW2 as an expert witness who stated that she is a software engineer. She stated that she was aware that ANEC was mandated to electronically transmit or transfer the result from the polling unit direct to the collation system as prescribed by ANEC. Stated that the IRF portal is part of the technological architecture developed or deployed by ANEC for the storage, management, display, and uploading of polling unit results to be accessed by the public. However, under cross-examination, he admitted that he was not familiar with the operations and application of the BVAS machine, and that his investigations and findings were on the ANEC IRF portal. He also agreed that it was only ANEC that could prescribe the method of transmission of election results. PW4 was also called as an expert witness by the petitioners, even though he stated that part of his brief by Labour Party was to determine ANEC compliance with the Electoral Act 2022 and the ANEC regulations and guidelines for conduct of the election 2022. He prevaricated under cross-examination by the first respondent when he first stated that ANEC at the IRF portal is an electronic collation system, but later recanted and said the IRF portal is not capable of collating and or tabulating the results of an election. The witness also stated under cross-examination by the second and third respondents that it is the image of Form EC8A that will be transmitted to RF, while the hard copy of the Form EC8A will be taken to the Ward Collation Center. As for PW7, also called as expert witness by the petitioners, our evidence was basically in respect of the health status of Amazon Web Services, which hosted the ANIC RF portal. The testimony of PW8, the cyber security expert, also called by the petitioners, also related to the ANIC RF portal. On the part of the first respondent, RW1, Dr. Lawrence Bayode, the Deputy Director in the ICT Department of the first respondent, has testified that contrary to the assertion of the petitioners in paragraph 37 of the petition, there was no collation system of the first respondent, which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer. He stated that the prescribed mode of collation was manual collation of the various forms EC8As, EC8Bs, EC8Cs, EC8Ds, and EC8Es for the presidential election. He explained that the BVAS machine was designed to upload accreditation data at the end of the accreditation process and scan and transmit the results of the polling unit results through the e-transmission system to the IRF portal. Even as this witness was cross-examined by the petitioner's counsel, he was not cross-examined on his evidence that ANIC has not established any collation system which results will be electronically transmitted from the polling units. Thus, his testimony on that fact remained unchallenged and uncontroverted. It's a certain law that the court has a duty to act with unchallenged and uncontroverted evidence. The Bromwen Energy Trading Company Limited, OAN Overseas Agency, Ogunyade versus Oshunke, and others. In addition, RW2, called by the second and third respondents, had testified that the first respondent, through its chairman, made clarifications on 23rd of February 2023 that raw figures of election results will not be transmitted electronically by the first respondent, as such transmission was susceptible to hacking. The identified exhibits R24 and RA24 and RA25 as documents he referred to in his statement. These are the certified true copies of pages 28 and 27 of the Tribune papers of 23rd February 2023, wherein the chairman made the said clarification. As indicated in our ruling on objections to documents, the petitioners did not object to the contents of exhibits RA24 and RA25, but only stated that they were objecting to the heading, but not the contents. We overruled that objection in our ruling because the reason advanced by the petitioners' counsel did not amount to a proper objection to those documents. Although also noteworthy that the petitioners never cross-examined RW2 on his oral evidence and the said exhibits in support of his oral evidence. In exhibit RA24, the ANIC chairman was reported to have stated that raw figures will not be transmitted because the law does not allow for electronic transmission of results and because it is susceptible to hacking. Stated that only scanned copies of polling unit results will be uploaded to the RF for public view. From the evidence led by the parties on this issue, it is clear that apart from testifying that the first respondent failed to transmit scanned copies of polling unit results to the ANIC RF portal, none of the witnesses called by the petitioners had given evidence of the existence of any collation system to which the results shall be electronically transmitted by the presiding officers of the first respondent. Contrary to the contention of the petitioners that under the regulations it will not be possible to collect the presidential election results without verifying them with the electronically transmitted results, paragraph 92 of the same regulations categorically provides that at every level of collation where the ANIC copy of collected results from the immediate lower level of collation exists, it shall be adopted for collation. In addition, paragraph 48C of the regulation provides that if no result has been directly transmitted electronically for a polling unit or any level of collation, the provision of clause 93 of this regulation shall apply. The said clause 93 of the regulations, which I had earlier quoted, provides that where the ANIC hard copy of collected results from the immediately lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the RF portal continue collation. And where none of this exists, the collation officer shall ask for the duplicate copies issued by the Commission to the Nigerian police or to the agents of political parties in that order. The foregoing provisions of the Electoral Act and the annual regulations clearly show that it is not correct, as contended by the petitioners, the results of the election cannot be validly collected without the electronically transmitted results. Indeed, the regulations primarily provide for manual transmission or transfer and collation of results. There is nothing in the Electoral Act or the annual regulations and guidelines to show that an electronic collation system was prescribed by the Commission, which results will be electronically transmitted. Thus, the petitioners were unable to establish the assertion that the first respondent is mandatorily required to electronically transmit the polling unit results to a collation system. First respondent, on the other hand, has adduced unchallenged evidence that apart from the RF portal, no collation system was established by the first respondent, which result of the presidential election must be electronically transmitted for collation. It is therefore my finding that both the Electoral Act and the regulations and guidelines provide for manual collation of election results and the election electronic transmission to a collation system apparently introduced by the first respondent in the regulations and guidelines are not mandatory as contended by the petitioners here. Also, my finding based on the evidence adduced that the only collation system put in place by the first respondent in the conduct of the presidential election is comprised of the physical collation centers in the registration areas or ward collation centers, local government area collation centers, state collation centers, and the national collation centers elaborately stated in paragraphs 47, 50, 53, 54, and 55 of the regulations and guidelines for the conduct of elections 2022. With regard to the petitioner's contention that the first respondent deliberately failed to upload the presidential election results to the INEC results viewing portal, RF real time, the petitioners averred in paragraph 53, 97, 98 petition that the petitioner also 53. The petitioner also contend that in manifest violation of the first respondent regulations and the Electoral Act 2022, results of the presidential election held in the polling units were not fully uploaded on the RF as at the time of the purported declaration of second respondent as the winner of the presidential election, which gave room for manipulation of the said results by officials of the respondent. 97. The first respondent via a written communication sought to excuse the manifest non-compliance with the requirements of the Electoral Act 2022 and the regulations by claiming that there were glitches in the electoral system which prevented it, that first from uploading the results of the presidential election from the polling unit to the RF portal on the day of the election. The said written communication is hereby pleaded. 98. A petitioner shall contend that the alleged glitches in the electronic system installed and managed by the first respondent were a ploy invented by the first respondent to credit unlawful votes to the second respondent and thereby wipe out the clear advantage which inured to the petitioners following the lawful exercise of voting rights by the electorate. In response to the above allegation, the first respondent adverted in paragraph 59, 55, 7, 8, 9, and 10 of their reply to the petition. That's here. In paragraph 37 of their reply to the respondent's reply, the petitioners have again denied that there was any technical glitch and maintained their assertion that the failure to upload the results on the IRF was a ploy by the first respondent to manipulate the results. They stated that they would rely on the server logs and server content of the IRF posted on the AWS cloud platform to show that the results of the election were uploaded on the IRF portal, but the first respondent attempted to delete or remove the uploaded results. It is said that a petitioner who alleges non-compliance with Electoral Act, have the
Ilé loud o. Ilé ga díẹ̀ o. Ẹ̀yin ará mi nínú Olúwa. Wọ́n ti kàbò tán látàárọ̀ ni. Mo sùn mo ti jí. Wàláì, mo sùn mo jí. Mo sùn mo jí. Mo sùn mo jí. Mo lálàá. Mo sùn mo jí. Mo lálàá. Wàláì. Wàláì.
of the Labour Party, the petitioner is sharing, but she contested election as is candidate for member House of Representatives for Ogoja, Rogyala, Federal Constituency of Cross River State. He stated that for an IT application, the SDLC includes requirement gathering, analysis, and design. Election centers to and design, yes. The development from implementation. This is the court staging the software and deployment. He stated that she was aware that at the process of testing and staging of software code and problems of challenges, any problems of challenges with the software will usually show or be flagged. He stated that each function is supposed to be tested and any issues flagged ought to be remedied before deploying software. He stated that if a software from application has any glitch, such a glitch will pop up that is flagged at the testing stage. He stated that from her preliminary review of the public viewing facing the RF website, is aware that the polling unit results images are stored in Amazon S3 and AWS storage service. He stated that as an employee of AWS, the AWS has a service level agreement, SLA, with its customers, which is accessible to the public on docs.aws.amazon.com, and that by the SLA for S3 service, it is designed to provide 99.999% durability, 99.99 availability of objects not over a year. He said this is accessible to the public on http docs.aws.amazon.com, Amazon S3 latest user guides from data durability.html. He stated that the AWS servers are hosted in 33 regions. The health status of AWS cloud service for all regions for the past 12 months from date is accessible to the public on http://health.aws.amazon.com health/status. It stated that the health status of each service in each region on February 25, 2023 indicated that there were no glitches on any of the AWS cloud servers. Stated that from the post-event summary by AWS, the last time a significant outage occurred on the AWS cloud servers was on December 10, 2021, which was an internal connectivity issue that affected EC2, API, and Container API, among other services access issues affecting only one region. He said this is available to the public. AWS 7 stated that she was aware that a glitch in the software means a malfunctioning, as a result of which the application is not able to perform properly, and that fixing a glitch in a software application by the creation of patches refers to a series of changes made into the system by writing small code, which is imputed into the software, then its current state and thereby function properly. On cross-examination by the first respondent, PW7 admitted that she missed that she means production maintenance, which is an important element of software development life cycle. She denied that glitches occur at post-production maintenance stage and stated that it appears at the testing stage. She stated that she was aware of personal health dashboard, but stated that the first respondent's personal health dashboard is not before the court. She admitted that the EWS adopts a shared responsibility model in which AWS plays its part while the customer plays its own part when it comes to security. She admitted that the report that only shows the health status of all AWS services in all regions in terms of the infrastructure and not security. He admitted that in order to know what happened on application deployed on AWS infrastructure by a customer, it is not necessary to get a technical report. EW7 also stated that she is familiar with AWS CloudTrail, and there is a CloudTrail for every AWS account and for every API action made on that account. She admitted that she did not produce the CloudTrail for any application before the court. He denied that the CloudTrail is the best account of what transpired on any developed application, but did not state the best way to know what transpired. He stated that it is highly unusual for glitches to occur for primary functions of applications. He stated that she was not aware that glitches happened in the Central Bank of Nigeria e-money project, or the one that happened with the MTN monopoly. He admitted that she was a candidate for the Labour Party at the last election. He also admitted that the subpoena under which she came to court was served on her personally and not on Amazon Web Services. Also on cross-examination by the second and third respondents, EW7 admitted that exhibit PCJ2, which she presented as her employment verification letter, was not signed by anyone, but insisted that there is the name of Employment Resource Center written on it. He also admitted that she had been attending the court and watching the proceedings before the day her testimony. He admitted that the report he presented before the court is public information posted by Amazon, that it is available and accessible to the public. She, however, insisted that the report is hers because she was the one who downloaded it, brought them to the court. EW7 also admitted under cross-examination that she won primary election for her constituency under Labour Party, the second petitioner, and that she even filed an action against ANIC because she was not placed on the final list of candidates published by ANIC. She admitted that her complaint was because she tried several times to upload her information on ANIC's site, but all her efforts failed because of network failure. She admitted that network failure can happen to either end of an application, even as she disagreed that there was a glitch. ANIC's site, she admitted that in her affidavit, stated that ANIC's site crashed. EW7 also stated that she was aware that AWS experienced outage of several hours on Tuesday, 28th February 2017, that as at 2021, AWS also was reported to have suffered more than 27 outages. He also admitted that what was sent to RF was the image of the phone EC8A. On cross-examination by the fourth respondent, PW7 stated that she did not know about password protocols and cannot speak about password protocols to modify the applications of ANIC. She admitted that the open cross-access information she downloaded in her report cannot be amended by her. In fact, she admitted that she was not representing Amazon Web Services in this case. However, insisted that she is an expert. She stated that she was aware of glitch which affected Japan brokers in September 2021, but stated that the last one she was aware of was in December 2021. As to whether glitches can happen again, he stated that anything possible. In his evidence, PW1, Dr. Chibike Ugoike, another expert witness, called by the petitioners, stated that he is a cybersecurity and risk advisory consultant and that he was approached by the Labour Party to provide expert evidence in this petition. He said he had read the Electoral Act 2022 and the INEC regulations and guidelines for the conduct of elections 22 and the INEC Manual for Election Officials 2023, with particular attention to the relevant provisions dealing with uploading and transmission of election results from the polling units using the BVAS to IREF portal. He stated that he has also read the petition as well as the reply to the petition filed by the first respondent. He stated that from his reading of those documents and processes, when a software application undergoes the required minimum testing for deployment, any functionality thereof, stated that the purpose of testing is to remedy or resolve that errors before the application deployed production. On cross-examination by the first respondent, PwC stated that he was approached on 10th March 2023 and he finished his work sometime in May 2023. He said that he did his preliminary report on 17th and 18th March. On 17th and 18th March 2023 and concluded the final report at the end of May 2023. PwC stated in paragraph 14 of this adopted written witness statement that he read the petition and the first respondent replied to the petition in doing his work, stated that he could not recall whether he read the petition. But when his attention was drawn to paragraph 14 of his statement, he agreed that he had read those pleadings. He admitted that it is not impossible for errors to occur after deployment of technology or application. When referred to paragraphs 22 and 23 of his statement, he stated that he referred to the metadata on the IREF in 3 polling units. He established that it is possible to show metadata. He stated that there were errors in those polling units and he did not have examined the physical copies of the forms EC8A of those polling units. He stated that from the tabulation of the metadata, he could not tell that whether the results stated in those polling units were collected. He stated that all the work he did was on his computer. He confirmed that the AWS security model is a shared responsibility model between AWS and the client. He stated that he was aware of the CloudTrail and confirmed that the CloudTrail will explain the availability of the application of INEC on the AWS infrastructure. AWS, who insisted that there was an electronic collation system, only pointed to an upload at the last paragraph of Exhibit ECK2 and stated that it means an electronic collation system. When cross-examined by second and third respondents, PwC denied that it was part of his brief to assist the Labour Party to respond to the respondent's reply. He admitted that he did not inspect any of the BVAS machines and did not interrogate Festus Okoye, whose statements he referred to. He confirmed that Exhibit A, which he attached to his report, the metadata of 23 pages, showing multiple uploads. He denied that it contains information which are coded and not explained, and insisted that the information he provided are encrypted and readable. He admitted that he supplied some links in some paragraphs of his report that stated he did not expect the court to go and browse, access, and download the information contained from those links. When cross-examined by the first respondent, PwC admitted that he downloaded the 12 polling unit results attached to his report from the IREF, and he did not interact with the presiding officers of those polling units, and did not see the hard copy of those results. Could not also tell whether those results have been collected. Starting with the evidence of PwC7, is evidence that she is a person who has an interest to serve in this petition, being a member of the second petitioner, under whose platform she contested election for House of Representatives. Her interest in this petition is further underscored by her admission that she has been attending court and watching the proceedings and testifying as a witness. Her testimony for essentially a demonstration of her support and loyalty to the second petitioner. Her claim of being an employee of Amazon Web Services is also suspect, as she produced no credible evidence to that effect. Exhibit PCJ2, which is the paper she presented as evidence of her employment by AWS, is obviously a false paper. Has no author, although she insisted that the author is Employee Resource Center. The paper was also not signed. Her evidence adds no value to the petitioner case, because she stated that her evidence relates to the health status of AWS in terms of infrastructure and not in terms of security. Admitted that the expert report in the PCJ, which she brought to court, are actually documents publicly available on Amazon website, which she downloaded. And her only claim to its ownership is that she was the one who downloaded it and brought it to court. She even admitted that she could not add or subtract anything from the reports. Those reports are obviously not her own. She also admitted that the health status of the first responders application posted on the AWS is not before the court. A conclusion on the totality of this witness that it is devoid of any value. As for PWA, he has demonstrated that he worked to an answer. Not only did he admit that he read the petition and reply of the first respondent in the course of his commission work, he also stated that he read the Electoral Act and annual regulations and manual for election officials. On the authority of Ladoja and Ajimobi, the evidence of this witness is also not of any probative value. Apart from the above, the other witnesses or petitioners, especially PW4, PW9, 10, 12, and 13, all stated that they voted and everything went well in their respective polling units. In particular, PW4, PW10, and 13 all stated that their polling unit results were taken to collation centers. Therefore, even the evidence of the petitioner witnesses showed that the polling unit results were physically taken to the registration areas for work collation centers. The petitioners have left no evidence to establish the existence of any collation center with the potential election results were to be electronically transmitted for collation. On the part of the first respondent, RW1 testified that the failure to upload some of the results of the presidential election to the IRF portal real time on 26 February 2023 was due to a technical glitch experienced on their transmission system. RW1, through whom the first respondent tendered exhibits RA6 and RA7, stated that at the end of the polls, in some polling units, on 26 February 2023, it was observed that the first respondent was observed at first respondent by the first respondent that polling unit results being uploaded to the annexed e-transmission system by the presiding officers were pushed to the Senate and House of Representatives modules on the IRF, but the results of the presidential election were not being pushed to the presidential module on the IRF. That based on error levels and reports by security agencies that the first respondent servers may be subjected to attacks on election day, the first respondent first course of action was to investigate whether the servers were being attacked. The preliminary investigation showed that there was no attack, but the issue was a HTTP 500 error from which within the application, which are mostly errors due to problems of configuration, permission, or failure to create application resources correctly. That a thorough investigation revealed that the e-transmission was unable to map the uploaded results of the presidential election to any specific state, and that the presidential folder structure, which was meant to organize the uploaded result sheets in order of election, state, local government, area, ward, polling unit, was causing the application to crash and return as server error whenever it tried to create the folder structure for the presidential election. RW1 explained that creating a folder structure organized the uploaded results in the hierarchy of elections, state, local government, ward, and polling unit was a new feature introduced as an improvement in the transmission system. And that the whole system randomly saved uploaded results by timestamps, making it difficult to upload results sheets by election or by state. It stated that the deficiency was observed after the Ocean State governorship election 2022. RW1 stated that during the election of 26 February 2023, the application was able to query and detect the base states for the senatorial districts and federal constituencies based on the mapping of all central districts and federal constituencies, their respective states, and that this mapping still exists in the database. And the upload was successful because it was able to identify the state and build the folder hierarchy for the results organization. But for the presidential election, the application crashed because the presidential election does not belong to any state on the first respondents database. And any attempt by the application to build a folder structure to organize the election results failed with a HTTP error response. RW1 stated that since these were live servers that were being used for the election, extra care was taken not to cause a complete outage, and four application patches or updates were created and deployed immediately with the aim of fixing the HTTP error. It stated that the first presidential election results were successfully uploaded at 8:55 p.m. on the 25th February 2023. Further stated that to confirm that the glitch actually happened, as well as the time that all patches to fix the error were created and reviewed on AWS CloudTrail and AWS functionality that allows enabling operational and risk auditing. He added that all actions taken to fix the error are recorded as events in the CloudTrail log. He said that the technological glitch experienced on the transmission system was not deployed to manipulate the election, and the glitch did not affect the results of the election. He then tendered the RA6 and RA7, the CloudTrail log, and his certificate of compliance with Section 84 of the Evidence Act 2007, and identified same as the documents he referred to his witness statement on oath. And cross-examination by the petitioners. RW1 confirmed that testing was carried out on the e-transmission system, the first respondent, on the 4th February 2023, before it was deployed and a report was issued. When shown a report produced on subpoena, he identified same as a report on vulnerability assessment and penetration testing data, dated 22nd February 2023, but stated that it was not the report of testing carried out on the e-transmission system, 4th February 2023. Petitioners then tendered the report of vulnerability assessment and penetration testing through which was admitted as X1. From the evidence adduced on this point, it is clear that the petitioners are unable to substantiate their contention, burden of proof of which was on them by virtue of Section 131, subsection 1 of the Evidence Act 2007. They have failed to establish that the first respondent had deliberately failed to upload the results of the presidential election to the RF in order to manipulate the results in favor of the second respondent. The first respondent, on the other hand, has offered credible evidence in the form of RA6 and AR7 to show that its e-transmission application posted on the Amazon Web Services, which is supposed to upload the results of the presidential election to the RF, has suffered a glitch on the election day on 26 February 2023. On the preponderance of evidence, I am convinced that the petitioners have failed to establish their assertion that the first respondent had deliberately failed to upload the results of the presidential election to the RF in order to manipulate the results in favor of the second respondent. As I stated earlier, the electronic transmission system of electronic transmission of results of an election is not expressly stated anywhere in the Electoral Act, but was only introduced by the first respondent, that is ANIC, in its regulations and guidelines 2022, and in the ANIC manual for election officials 2023. As Section 134, subsection 2 of the Electoral Act 2022, only an act of omission which is contrary to the Electoral Act 2022 can be a ground for questioning an election. Thus, complaints relating to non-compliance with provisions of the regulations and guidelines or the manual of election officials are not legally cognizable complaints of questioning an election. Interpreting Section 138, subsection 2 of the Electoral Act 2010, which is similar to Section 134.2 of the Electoral Act 2022, the Supreme Court in Newsom and Peter cited as follows. The above provisions appear to be quite clear and unambiguous. While the Electoral Commission is duly conferred with powers to issue regulations, guidelines, or manuals for the smooth conduct of elections, by Section 138.2 of the Act, so long as an act of omission regarding such regulation or guideline is not contrary to the provisions of the Act itself, is not of itself a ground for questioning the election. See also JGD and INEC. Since, as shown above, electronic transmission of election results is not specifically provided for in the Electoral Act 2022, but was only provided for in the regulations and guidelines for conduct of elections 2022 and INEC Manual for Election Officials 2023. The failure to electronically transmit election results cannot be made a ground for challenging an election under Section 134 of Section 1B of the Electoral Act 2022. The petitioners also allege in paragraph 59 of the petition that the first respondent failed to record in the prescribed forms the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials on the prescribed forms EC 25A, EC 25A1, EC 8B, and EC 8B1. That is to say, electoral materials received for local government areas, electoral materials distribution for registration areas, electoral materials received for local government areas, electoral material distribution for RAs, electoral materials received reverse logistics and polling unit materials in respect of states where the respondent is purported, where the second respondent purportedly won. The petitioners further allege that following the order of court for inspection, they applied through their campaign organization and lawyers for the forms, and the first respondent refused to give or issue those forms and refused to allow the inspection of the forms by the order. In response to the petitioner's allegation, the first respondent countered that its officials duly recorded in the prescribed forms the quantity, serial numbers, and other forms, other particulars of the dossiers, ballot papers, and other sensitive electoral materials in the prescribed forms EC 25A, EC 25A1, EC 8B won the election are done in the states where the petitioner won the election, as the procedure adopted in the election across all the states of the Federation are uniform and the same. The first respondent further stated that duly complied with the order of inspection granted by the Honorable Court, and the petitioners were not denied access to the EC forms EC 25A, EC 25A1, EC 8B, EC 8B1 raised by the petitioners. It was the subordinate senior counsel having regard to the state of the pleading and the issues of fact in contention. The onus is on the first respondent to prove that there was indeed due compliance with the provisions of Section 73 of Section 2 of the Electoral Act. Since petitioners are asserting the negative, while the respondents are asserting the positive. Relied on the decision of this court in First Bank Nigeria PLC, Adjacent Business Investments, and Royal United Nigeria Sterling Bank PLC, admitted that the first respondent did not leave any evidence in proof of their positive assertion there was compliance with the provision of Section 73 of Section 2 of the Electoral Act. Learned Counsel submitted that on the part of the petitioners, they have led evidence through PW12 that the petitioners obtained order of disposition of documents, but the first respondent had refused to produce the forms, despite several letters demanding the forms from the petitioners, which were tendered as CCQ1, CCQ6. He added that the petitioners have also served subpoena Duchess Tekum on the first respondent to produce said forms the forms, but the officer of the first respondent, the deputy director, certification, complaints, and legal drafting, who came to court in answer of the subpoena on 20th June 2023, failed to bring the form. Counsel asked the court to invoke the provision section 167E of the Evidence Act against the first respondent and hold that the forms, if produced, would have been unfavorable to the first respondent. He further submitted that the non-compliance with section 73 of the Electoral Act has been established, which has invalidated the election in those states which the second respondent was declared to have won, namely Benue, Borno, Ekiti, Gawa, Kogi, Para, Niger, Ogun, Ondo, Oyo, Rivers of the states, which are shown in the form ECADA, written in evidence as exhibit EBF. He pointed out that Section 135, Section 1 of the Law Act 2022 only deals with non-compliance generally, but Section 73, Subsection 2 of the Act has provided a specific effect of non-compliance with provisions. Relying on Crown's Townsend Organization of the National Institute of Policy and Strategic Studies, he urged the court to hold that substantial non-compliance has been established. Arguing per contra, Learned Senior Counsel for the First Respondent referred the court to Section 135(1) of the Electoral Act 2022 and submitted that the petitioner complained of non-utilization of prescribed forms, even though not proved, and not without showing the effect on the election be a basis to avoid an election. He submitted that the attempt by the petitioners to exclude Section 73 of Section 2 of the Act from the ambit of Section 135, Section 1 is non-starter because the non-compliance referred to in Section 135(1) is for the provisions of the Act, and no part of the Act was excluded by the section. Posited that for non-compliance with Section 73 of the Act to avoid an election, it must have substantial effect on the election, and the petitioners have neither proved that non-compliance or shown that it has substantially affected all of the presidential election. Urged the court to so hold. Petitioner had contended that since they are alleging that the first respondent failed to record in the prescribed form the quantity and particulars of the materials used in the election, they are alleging the negative, and as such, the burden is on the first respondent to establish that they have fully complied with the provisions of Section 73 sub 2 of the Electoral Act. They have relied on the terms of First Bank of Nigeria, Aviation Business Investment Limited, Royal United Nigeria for Sterling Bank. While it is true that the burden of proof is generally on the party that asserts the affirmative for an issue and not on the party who asserts the negative, there is an exception to that general principle. Where a negative assertion forms an essential part of the party's case, the party is on him to establish that fact. This position was clearly stated by the Supreme Court in the case of Buhari and Ani, where Toby JSC stated held thus, quote, a negative allegation must not be confounded with the mere charge of an affirmative one. The true meaning of the rule is that where a given allegation, whether affirmative or negative, forms an essential part of a party's case, the proof of such allegation rests on him, thus of court. Again, this court in Dashi and others versus Proven and others espoused this legal position when Ugo JCA held as follows. Quote, I am in no doubt that this argument of appellants about negative and positive assertion is misconceived. For while it is true that the burden of proof is generally on the person who substantially affirms the positive of an issue and not on the person who makes a negative assertion, there is a caveat to that principle to the effect that where a negative assertion forms an essential part of a plaintiff's case, as it evidently is the case of the appellant, the burden of proof of such allegation rests on him. The law on this point was lucidly stated by Bowen LJ, Abrak, was a Northeast Railway Company, 11 Queens Bend Division 440, 457 when he said that, quote, in an action for malicious prosecution, the plaintiff has the burden throughout of establishing that the circumstances of the prosecution were such that the judge can see no reasonable and probable cause for instituting it. In one sense, that it is the assertion of a negative, and we have been praised with the proposition that when a negative is made out, the onus of proof shifts. That is not so. If the assertion of a negative is an essential part of a plaintiff's case, the proof of the assertion still rests on the plaintiff. The terms negative and affirmative are, after all, relative and not absolute laws of court. In the instant case, the petitioners have made their allegation of non-compliance with Section 73(2) of the Electoral Act 2022 by the first respondent as an essential part of their case in challenging the results of the election declared by the first respondent. Not only are the petitioners statutorily required by Section 135, Subsection 1 of the Electoral Act to establish substantial non-compliance with the provisions of the Act, they are required to show how such non-compliance has substantially affected the result of the election. As rightly observed by the learned senior counsel for the first respondent, the non-compliance that will not invalidate an election under Section 135(1) unless it is shown to be substantial and to have substantially affected the result of the election, encompasses non-compliance all provisions of the Electoral Act, including Section 73, Subsection 2 thereof. In other words, Section 73 of 2 is not derogated from the ambit of Section 135, Section 1 of the Act. Indeed, in Buhari and Anik, Joe is while considering considering Section 1.51 of the old Electoral Act, similar to Section 1.51 of the Eastern Electoral Act 2022, had held at page 48 paragraphs B to D that, quote, a petitioner who files a petition under Section 145(1) of the Electoral Act has the burden to prove the ground or grounds. This is because he is the party alleging the grounds and he has a duty to prove the affirmative. He is the party who will lose if no evidence is given on the grounds. If the party does not prove his case under Section 145(1), the action fails. Therefore, the petitioners who have alleged non-compliance with the Section 73 of Section 1 as part of their course of action, have the burden to establish that non-compliance accordance with the requirements of Section 151 of the Act. The petitioners have also evidence of PW12 and on exhibits PCQ1 to PCQ6, also tendered through PW12. The exhibits acknowledge copies of letters dated 6 March 2023, or 10 March 2023, 10 March 2023, and 20th March 2023, all written by the petitioners or their solicitors to the chairman of the first respondent, demanding for inspection of documents and for certified true copies of the electoral forms. The petitioner also relied on subpoena duces tecum served on the first respondent who produced the said forms. In his testimony at paragraph 58 to 60 of his adopted written statement on oath, PW12 merely stated that the petitioners made several applications through his campaign organization and solicitors for certified copies of election documents and data relating to the presidential election, but they were denied by the first respondent, and that the first respondent had failed to record in the prescribed forms the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials. The record of proceedings of this court also shows that at the instant of the petitioners, subpoenas dated 30th May 2023 and 13th June 2023 were issued from the chairman, first respondent of this document. The record also shows that on the 20th June 2022,
kí ló fa dúndùn ṣé kìí ṣe pé tó fẹ́ sòjòrò tó dé bá ti fẹ́ sòjòrò lẹ́mọ̀ ń dún bá wọn. Ẹ dákun ẹsẹ̀ kínní yín òde wá ní pọ́n tẹ́wàá mọ́ àwọn wa létí gbogbo bẹ́ẹ̀ ṣe ń sọ gírámà bọ́tẹ́ bá sọ gírámà yín tẹ́ ẹ bá sọ gbogbo gírámà yẹn tó jẹ́ pé ó rí ojú kan rẹ̀ padà wá fi lé ìwà náà ṣẹlẹ̀ o kí ló ṣẹlẹ̀ gọ́gẹ́ pé ní fún yín kí ló dé tẹ́ bá fẹ́ ṣe tẹ́ bá ti mọ̀ pé ẹ fẹ́ gbé kú òǹbí tó wà ibi tẹ́ fi sí náà tẹ́lẹ̀tẹ́lẹ̀ lẹ fẹ́ kó wà ẹ kúkú sọ tẹ́ bá dẹ̀ fẹ́ kúrò ẹ sọ ìwọ grammar ẹ kàn sọ grammar kẹfẹ́ dorí wa rú ẹ ń wé sí ẹ fún wa lówó ṣẹ́ ẹ jẹ́ kárí ṣẹ́ṣe ẹ fún wa lówó oúnjẹ ẹ bọ́ wa ẹ tún wé sí dátà wa látàárọ̀ kùtù kí ló ṣẹlẹ̀ gangan ẹ ń wé sí dátà wa ẹ̀yin dẹ̀ ní ẹ̀ níṣẹ́ tẹ́ pèsè fún wa 5 billion lẹ́sán náà pín pẹ́kẹ́ fún stéètì gbogbo àpò nílẹ̀ kó sí kí ló sì àdé ẹ̀dẹ̀ wá sọ grammar látàárọ̀ ẹ̀ ń waste data àtàsìkò tó káwọn èèyàn lọ fi sùn kán lọ ṣiṣẹ́.
Observe Section 741 of the Electoral Act 2022-23 mandates the resident electoral commissioner in a state where an election is conducted within 40 and after made him by any of the parties to an election petition, cause a certified true copy of such document to be issued in the said party. Subsection 2 of that section even provides that any resident electoral commissioner who fails to comply with subsection 1 commits offense liable conviction to a maximum of 2 million naira or imprisonment for a term of 12 months or both. A look at the letters exhibits PCQ1 to PCQ6 show that they were all addressed to the chairman of PANEC instead of the resident electoral commissioners in the state, as required by the petitioners, as section 74 subsection 1 of the Electoral Act 2023. It is therefore clear that the petitioners have failed to follow the clear legal procedures requesting for those treatment. Also, when the record shows that the claim served upon the first respondent were also served on the chairman of the first respondent, and as stated by the officer who answered the subpoena, same was served only the previous day for her appearance in court. From his evidence, PW12 had stated that apart from voting at his polling unit 04 at Dawaki, Abuja, the only role he played in the 25th February 2023 general election, presidential election, was that he was a member of the second petitioner's special room. And on cross-examination by the respondent, she stated that she was neither a polling agent nor a coalition agent. It's evidence that the first respondent had failed to record in prescribed forms the quantity, serial numbers, and other details of the electoral materials can only be hearsay evidence, which has no probative value. Also, the mere production of exhibits PCQ1 to PCQ6 cannot establish an allegation of non-compliance with section 73(2) of the evidence Electoral Act. The Electoral Act 2022. Apart from the evidence of PW12 and exhibits PCQ1 to PCQ6 tendered through him, the petitioners have produced no other evidence to substantiate their allegation that the first respondent failed to comply with the provisions of Section 73, Subsection 2 of the Electoral Act 2022. Rather, PW came as EA, the supervisory presiding officer for Madagali Ward in Adamawa State, who was subpoenaed by the petitioners to testify on their behalf, stated in paragraph 4 and 5 of his witness statement of oath that as a presiding officer, he reported to the local government area annual office in Pula, Madagali local government area in Adamawa State, on the 24th February 2023 to collect the sensitive and non-sensitive materials for the 25th February presidential election and National Assembly elections, and that after collecting the materials, he proceeded together with security agents and other annual officials, which consisted of presiding officers, assistant presiding officers 1, assistant presiding officer 2, and assistant presiding officer 3, Madagali Ward, that evening to the registration area. This evidence was also to the effect that on the day of the elections, everything went well, and after sorting and counting the votes, the presiding officer did the entry and snapped the results to Beavers for the upload and transmission of the results to the annual portal, but were unable to upload. And when they complained to him, he requested them to come to the registration area. It is therefore clear from the above that the petitioners were unable to establish the allegation of non-compliance by ANIC with Section 73(2) of the Electoral Act 2023. The evidence PW2 and Exhibits PCQ1 to PCQ6 have not been able to rebut the presumption of regularity, which inures to the first respondent under the law, which can only be rebutted with cogent and credible evidence. APC and Sheriff, others. From the totality of the evidence adduced on this issue, I'm of the considered view that petitioners have failed to prove substantial non-compliance with the provisions of the Electoral Act 2022. 2 is therefore resolved against the petitioners and in favor of the respondent. Issue 3 is whether from the totality of the evidence, the petitioners have proved that the presidential election held on 25th February was invalid by reason of corrupt practice. Here again, we have considered the missions of counsel. So in their petition, the petitioner made allegations of suppression of scores, unlawful reduction and inflation of results, uploading of fictitious results, misrepresentation and manipulation of results where no election took place, overvoting and wrong computation of results. These allegations are contained in paragraph 60, 78 for the petition. In paragraph 60, 61, 62, 64, 65, 68, and 69 of the petition, the petitioners allege that due to the first respondent's refusal and neglect to upload and transmit the result of the election to the IRF on the day of the election, the first respondent suppressed the actual scores obtained by the petitioners. According to them, the suppression of the first respondent's scores, which occurred in 18,088 polling units, was orchestrated by the first respondent, deliberately uploading readable and blurred forms EC8S on the area, and thereby suppressed the lawful scores obtained by the petitioners in the said polling units. They further alleged that in Rivers State, during the collection exercise, the first respondent announced scores of the petitioners as 175,071 votes, and the second and third respondents as having 231,591 votes, when in actual fact, the petitioners' local votes are 205,110, while that of the second and third respondents ought to be 84. By uploading fictitious results in polling units where there were no elections, as well as uploading incorrect results. They stated that if the results of polling units, votes, local government states are properly tabulated and calculated as required by the Electoral Act and the regulations and guidelines for the election, the overall results of the election and the percentages scored by the political party will show that the petitioners won the presidential election of 25th February 2023. They stated on a report of the inspection of the electoral material. In the earlier ruling of this court on the preliminary objections raised by the respondents on the propriety of the averments contained in the petition, we held that apart from the allegations of inflation and reduction of votes in Rivers and Benue states, where the petitioners have stated the figures alleged to be inflated and reduced, the other allegations of the petitioners were nebulous and bereft of the material particulars. We held that the said averments contain no particulars of the polling units where the alleged infractions took place, or the figures alleged to have been inflated or reduced. We have struck out those paragraphs for offending paragraph 41D2 of the first schedule to electoral appointment 2. Indeed, apart from the strict requirement of stating material particulars in election petitions, it is also tried that in civil litigation, including election petitions, whenever fraud or any other crime is alleged, material facts of such allegation of fraud or other crime must be pleaded and clearly set out. The Omoborio and others was Najashi, ESO Limited and Honey Legion, Lorin and others versus Tangolana, others. The petition allegations of suppression of votes, inflation and reduction of votes, massive misrepresentation and manipulation by uploading fictitious results all amount to falsification of results of an election. This the Supreme Court held that allegations of inflation with non-existing votes is another way of alleging falsification of results. Indeed, in Haruna and Modibo, the Supreme Court held that where a petition is based on allegation of incidents of fraudulent acts, manipulation of results, or falsification of results, that allegation is criminal in nature, and evidence required in proof thereof must be clear and unambiguous. In other words, the proof must be beyond reasonable doubt. This section 135 sub 1 of the evidence and the cases of Buhari and Obasanjo, Manuel Umana, Ipiazo, Oti, Abubakar, and others for Yaradua, Omishore, Alibashola, Magaji, and all Progressive Congress. In order to establish falsification of election results, the petitioner must produce in evidence two sets of results, one genuine and the other false. In the cases of Kaki and PDP, Mobodo and Ono, Adewale and Olaifa, also Chima and Noze versus Dr. M. Obichere and others. And Joseph Olujimi Kolawole Abaje versus Babatunde Raju Fashola. The Okichuku and another versus Onyebu. To prove their petition, the petitioner also, who indicated during pre-hearing, they will call 50 witnesses, or only 13 witnesses. They are mentioned here. Of the above 13 witnesses, only 3 had their witness statements on oath filed along with the petition. These are PW1, PW2, and PW12. In our ruling on the respondent's objection to the competence of the petition witnesses at the beginning of this judgment, we had struck out the evidence of PW3, 4, 5, 6, 7, 8, 9, 10, 11, and 13 on the ground that their witness statements on oath were not filed along with the petition as mandatorily required by paragraph 45B of schedule to the Electoral Act. However, even if the statements of those witnesses of the petition were to be considered, the question is, are those testimonies cogent and credible to establish the petitioner's allegations stated above? PW1's testimony was only on the alleged double nomination of the third respondent, Pecho proceeding, which we have already determined above. Even as he stated that he voted in his polling unit during the election, he stated that he did not play any other role in the election beyond exercising his civic responsibility. As for PW2, who said he was a software engineer, he stated that upon his reading of the relevant provisions of the Electoral Act and annual regulations, he is aware that the presiding officer in the polling unit is mandated to electronically transmit or transfer the result of the election direct to the polling to the collation system as prescribed by ANEC, and to also use the beavers to upload a scanned copy of the polling unit result to the ANEC result viewing portal area prescribed by ANEC. He said, from his knowledge of software engineering and computer operations, RF is a server and is accessible to the public. He said he was aware that the information or data generated or inputted in the beavers were operating online or offline, were transmitted to the ANEC servers, including virtual servers hosted on AWS Cloud. On cross-examination with his respondent, however, the witness admitted that his opinion was based purely on his reading of the Electoral Act and any guidelines, and that he was not familiar with the applications and operations of the Beavers machine. He stated that he did not play any role in the election. Indeed, as admitted by the witness, the statement, particularly paragraph 10 to 13, is a virtual reproduction of Section 38 of the Electoral Act 2022. On cross-examination by the fourth respondent, he admitted that he did not state his educational or professional qualification or experience in his statement on oath. He also stated that his investigation was based on publicly available application program interface, API, and collected information through it from ECHS. He said he did not have the documents and forms he used, and that everything was contrary to the speculation of the petitioners that ANIC was not prepared to conduct the promised credible and authentic transmitted election, or that it deliberately or mischievously allowed the compromised IT infrastructure to be deployed for the conduct of the presidential election. PwC confirmed that Amazon Web Services is the most secure service providers in the world, and that it is used by corporations, companies, individuals, and governments that are most concerned with his entire evidence. PwC did not talk about the contents of any result. Instead of supporting the petitioner's allegations, the evidence of this witness supports the case of the case respondent. As for PW3, PW5, and PW6, he merely tendered flash drives containing speeches of the ANIC chairman, Mahmoud Yakubu, and ANIC National Commissioner, Festus Koye, wherein they gave assurances that the results of the election will be transmitted to the RF, the public wing. Being mere assurances, the evidence of these witnesses had no utilitarian value in establishing allegation of corrupt practices made by the petitioners in this case. In his evidence, PW4 tendered exhibits PZD 1, 2, and 3, which he claimed to be the report of his analysis of the presidential election. The witness also tendered 4 boxes containing what he called 18,088 blood polling unit results downloaded from the RF portal, which were also admitted as exhibits PCE1 to PCE4. However, in the earlier ruling of this court on the respondent's objection, we have struck out exhibits PCD 1, 2, 3, as well as exhibits PCE 1 to 4, along with the witness statement on oath of PW4, which was not filed along with the petition since documents were tendered through the incompetent witness. The witness claimed in his evidence that from his investigations, the scores on forms ECHS of 39,556 polling units were inaccessible as they contained uploads not connected with presidential election, and that the number of accredited voters affected by the 18,088 blood results was 2,565,269, while the number of voters who collected their PVCs was 9,165,191. According to him, this signified that the votes of 5,533,553 accredited voters were discountenanced by the first respondent. He added that 23,119,298 registered voters collected their PVCs in those 39,546 polling units, and concluded that both the number of accredited voters of 5,553,553 and numbers of voters who collected their PVCs of 23 million plus polling units far exceeded the margin of lead from the first respondents' announced result of 1,807,206 over the first runner-up and 2,693,193 over the second runner-up. PW4 also stated that in Benue State, neither the results he obtained from the RF nor the CTCs who forms ECHS matched the results of the first respondent. He stated that the ANIC CTCs who forms ECHS showed that LP got 272,468 votes and APC got 256,852 votes, while the results from the RF portal got that LP got 260,790 votes, while APC got 268,630 votes. He added that the INEC announced results, but that LP got 308,372 votes, and APC got 310,468 votes. He concluded that by adding uncovered votes and deducting votes affected by overvoting, manipulation, alteration in Benue State, LP got 281,426 votes, while APC got 258,683 votes. A look at the 18,088 black polling units, the witness claimed to have downloaded from the ARIF portal, so that they were not certified by the first respondent. In secondary evidence of public documents, they are clearly inadmissible. This section 89E and 90E of the Evidence Act 2011, case of Emeka versus Ipiazu, others. Of note is that PW4 admitted under cross-examination by first respondent that the primary source of the data he used in his investigation is from the ARIF portal. This clearly means that he based his investigation on inauthentic data, since the essence of certification of public document is to ensure authenticity of public documents. In the cases of Ebwe and Araka and Emmanuel Basmana. Also under cross-examination, PW4 stated that his reference to Form EC8A and the result on ARIF portal are not the same thing, and that Form EC8A is a paper, while the result on ARIF is a copy of it. He particularly admitted that by his reference to blood Form EC8As on the ARIF, he was not suggesting that the hard copies of Form EC8As are also blood. This admission by PW4 also dealt a death nail to the allegation made by the petitioners in paragraph 60 of the petition that the first respondent to praise the first respondent's cause, the 18,088 polling units, by deliberately uploading unreadable and blood Form EC8As on the ARIF. In fact, PW4 had under cross-examination completely rubbished his own report when he admitted that the ARIF portal is not capable of collecting and tabulating the election results, and that it is the image of the Form EC8A that is transmitted to ARIF, while the hard copy of Form EC8A is taken to the collation center, which he stated is collected at what local government, state, and national collation centers. He also admitted that since the result in the Form EC8A is taken to the collation centers, the failure to transmit its image in ARIF or that image transmitted its blood will not change the result already entered in Form EC8A. Again, the witness admitted under cross-examination that his report in exhibits PCD1, PC2, and PCD3 only covered the two states of Rivers and Benue, and that he worked on only available data, that if he had more data in his report, would have been different. Further admitted that his report, exhibits PCD1, 2, and 3, is not a product of expertise, as any secondary school student can do the simple arithmetic involved in it. This admission by PW4 effectively rubbishes his entire report as inconclusive and manifestly unreliable. In the whole, the evidence of this witness, even if it were to be considered void of any probative value. As for the evidence of PW7, we had earlier analyzed and evaluated her testimony and found that she was not only a person interested in this petition. The report in exhibit PCJ3A, which she brought to the court purportedly as an expert witness, was merely downloaded by her from AWS site, which was openly accessible to the public. Her evidence is also of no probative value. With regard to the evidence of PW8, I have earlier analyzed and evaluated his evidence while resolving issue 2. Suffice it for me to state that I had found that PW8, having admitted that in the course of his commissioned work, he had read the petition and the first respondent's reply, as well as the Electoral Act and annual regulations and manual, and that he finished his final report in May 2022 during the hearing of his petition. PW8 had practically worked to a predetermined answer, and his evidence was of no probative value. PW9, who gave evidence as an accredited observer of the election, had stated that everything about the election in the polling unit, which he observed when as accreditation and voting took place, the votes were counted and the results were announced and recorded on Form EC8A, but was not uploaded on the RF, the polling unit. Under cross-examination by the respondents, he stated that from his observation, the election went on smoothly in his polling unit and that the election officials complied with the INEC regulations. He stated that the result was taken to the collation center by the election officials. Rather than support the petitioner's case, the evidence of this witness actually reinforced the response case that the election was conducted in substantial compliance with the Electoral Act and INEC regulations guidelines. PW10 stated that he acted as an ad hoc supervisory presiding officer for Madagali Ward, and that on election day he collected the materials with security agents and other INEC ad hoc presiding officers. He stated that voting went on well until 6:30 p.m. and all voters who were on queue at 2 p.m. duly voted at Unit 004 DISA. He stated that after sorting and counting of the votes, the presiding officers did the entry and snapped the results with the beavers, but were unable to transmit and upload same to the RF portal after the result of the National Assembly election was uploaded. Stated that when the presiding officers complained to him, he asked them to come to the registration area, where he requested them meet the registration area center head, who asked them to submit the beavers to him for transmission, but was unable to upload. On cross-examination by the First Respondent Council, PW8 stated that apart from the small issue between agents of APC and PDP, which was satisfactorily resolved, everything went well, and the results were entered in Form EC8S in the units and were properly announced. And added that the physical copies of the Form EC8S were taken to the Ward Collation Center. Cross-examination by second and third respondents, the witnesses have confirmed that notwithstanding the difficulty in uploading the results, the collation of Forms EC8A took place in the ward. The evidence of this witness also supports the case of the respondents rather than of the petitioners. PW's 11, head of the Legal Services National Information Technology Development Center, NIDA, merely stated that he was in, produced and tendered the following documents. A. Correspondence of documents, letters, emails sent by him, sent by or from Independent National Electoral Commission, National Information Technology Development Agency, requesting for the IT clearance approval of the IT infrastructure to be deployed and or deployed by INEC for the conduct of 2023 general election. B. The certificate of clearance approval issued by NIDA to INEC pursuant to any request in A above. C. The report submitted by INEC to NIDA containing certification for the testing review of the IT infrastructure deployed by for the conduct of the 2023 general election, stated that they don't have any of the documents in their office. Under cross-examination, second and third respondents stated that the NIDA Act does not contain cyber security standards. Also stated under cross-examination by the fourth respondent that their supervisory ministry is Ministry of Communication and Digital Economy, and that the minister stated that there were 16 million attempts to hack the INEC IT infrastructure on the day of the election. The evidence of this witness was no assistance to the petitioners. PW12, the petitioner's star witness, whose evidence was merely a copy of the averments in the petition, stated that on the day of the election, he voted at his polling unit at Dawaki, Abuja, after which he went to the situation room of his party. Second petitioner, he stated that apart from his polling unit and the situation room, he was not present physically at any other place on the day of the election. He stated that he was not a collation agent or polling agent in any polling unit or collation center. His evidence in chief was therefore mostly laced with hearsay, settled that hearsay evidence is inadmissible and has no probative value. Apart from his evidence in chief being inadmissible hearsay, Exhibit X1 The certified true copy of the judgment of Federal Court Abuja, good number FHC BGCS 1454/2022, was tendered through him under cross-examination by the first respondent, and he read judgment of the court, which was referred that the first respondent was under no mandatory obligation to electronically transmit or collect results of the election. Also admitted that he did not state in his statement on oath any figure unlawfully ascribed to the second respondent and third respondent and the first respondent. He also stated that his party had agents throughout the federation with over 133,000 votes. When asked by the second and third respondents council to state the scope of the Labour Party, the witness stated that he will not know scores of the Labour Party because the results are being uploaded on the IREF. He added that he will not know the lawful votes accredited because he is not an expert, and that the wasted votes are part of the statement made by the expert. Cross-examined by the respondent, PW12 said he was not aware that ANEC chairman had given a statement that ANEC will not transmit results electronically. When confronted by the fourth respondent council, he confirmed that the statement on oath wherein he stated that he will rely on the evidence of forensic expert was made on 20th March 2023, while the final expert report he was relying on was made in May 2023. Clear that PW12 for the life on an expert report that was not in existence at the time he made his statement. Obvious that the evidence of this witness lacks credibility and is therefore manifestly unreliable. PW13 was the only presiding officer called by the petitioners in this petition. His evidence was that in his polling unit 035 at Open Field or 04, local government area in Kaduna State, the election went well, and that thereafter all efforts to upload the presidential election results are subject in Form PC8A failed except the National Assembly results. But when all efforts failed, he proceeded to the collation center with other ad hoc staff. When cross-examined by First Respondents Council, he stated that he recorded the results manually, and the only problem he had that day was the uploading of the result. That when he could not upload the result, he called his supervising officer, who told him to take the result to the Ward Collation Center, which he did. On cross-examination by Second and Third Respondent Council, he confirmed that after recording the result manually, he signed and the party agents also signed. When cross-examined by the fourth respondent, he stated that after signing the result, he gave copies to party agents. The evidence of this witness actually supports the case of the respondents that the election was conducted in substantial compliance with the Electoral Act 2022. In Buhari and INEC and others, the Supreme Court clearly stated law as follows. A petitioner who contests the legality or lawfulness of votes cast in an election, the subsequent result must tender in witness all the necessary documents by way of forms and other documents used at the election. He should not stop there. He must call witnesses to testify to the unlawfulness of the votes cast and prove that the illegality or unlawfulness substantially affected the result of the election. The documents are amongst those in which the results are recorded. The witnesses are those who saw it all on the day of the election, not those who picked the evidence from an eyewitness. No, they must be eyewitnesses too. Both forms and witnesses are vital for contesting the legality or lawfulness of the vote suit for the other. It is not enough for the petitioner to tender only the documents. It is incumbent on him to lead evidence in respect of the wrongdoings or irregularities both in the conduct of the election and the recording of the votes. Wrongdoings and irregularities which affected substantial result of the election. Proving an election petition or proof an election petition is not as easy as the Englishman finding coffee on his breakfast table and sipping it with pleasure, particularly in the light of Section 146(1) of the Electoral Act. Petitioner has a difficult, though not impossible task, loss of court. Mohammed, another versus Anladi and others. In this petition, allegations against the first respondent such as suppression of votes, lawful reduction, and inflation of results, uploading of fictitious results, misrepresentation, manipulation of results where no election took place, and wrong computation of results is evident from the above that the petitioners have not led any credible evidence to substantiate those allegations. Of the 13 witnesses recalled, only 2 are presiding officers who were present at the polling, who are present at their polling units. Hence, the petitioners have not been able to establish any of those practices which they allege. The evidence of the witnesses which the petitioners call as experts who try to establish that the first respondent is mandatorily required to transmit election results for the purpose of collation or to link the delay in the upload of the presidential election results to average by the first respondent. Any of the malpractices which they allege are devoid of any value. Petitioner allegations have remained mere speculations and unfounded accusations. The petitioners have failed to establish beyond reasonable doubt the corrupt practices which they allege as required of them under Section 135(1) of the Evidence Act 2011. On the petitioner's allegation of overvoting, National Council for the First Respondent contended that to prove overvoting, the direct record of accredited voters and the BVOT machines are required alongside the voters register of the affected polling units. Pointed out that the petitioners failed to produce the BVOT machines and the voters register. They submitted the voters. Petitioners want this court to rely only on the expert opinion of PW4, which is not credible. Submitted that when PW4 was confronted with the results in polling unit 002 of Ward 7 of Bigima, LGA, River State, which was part of his report on overvoting. In exhibit PCD2, he stated that there was no overvoting, as the number of votes cast was 40, while the number of accredited voters was also 40. It relied on Oyetola and INEC at this court to discountenance PW4's evidence of voting. The petitioner's allegation of overvoting is contained in paragraph 72, 76, and 77 of the petition, which have been produced here. In the other ruling of this court, the respondents various perennial objections to the competence of the above affirmative petitioners' allegation of overvoting were upheld, and the court had struck out the said paragraphs for being vague, nebulous, and imprecise, having failed to disclose the specific polling units in the state where the overvoting is alleged to have occurred, the number of votes affected, the alleged margin of lead, etc. Indeed, in that ruling, we had observed that the forensic report containing the details of the polling units and other information which the petition said they have incorporated to the pleading by reference, but not filed along with the petition as to be part of the pleading. Proof of their above allegation of voting, however, the petitioners solely relied on the evidence of PW4, the subpoenaed expert witness, as well as the forensic report made by him, which is contained in Exhibit PCD 1, 2, and 3. Exhibit PW4's evidence was basically that from his investigation in Exhibit PCD 1, 2, and 3, he discovered that there was overvoting in 4,407 polling units, which is 2,317,129 voters who had collected their PVCs. He stated that this also exceeds the margin of lead of 1,807,206 over the first runner-up. He also stated that from his analysis of previous state results, the first respondent announced results which were inconsistent with those uploaded on the RF portal. PW4 also stated that from the Forms EC8As downloaded from the RF portal, there is evidence of manipulations and alterations in favor of APC and against the Labour Party LP. It stated from the results on the RF portal, LP got 208,564 votes, while APC got 118,999 votes in River State, as against 175,071 votes for LP and 231,591 votes for APC. Concluded that when the unlawful votes are deducted, it will amount to 205,110 votes for LP and 84,108 votes for APC. In the ruling on objections, witnesses, and documents made in the earlier part of the judgment, the witnesses stated on oath, a witness statement on oath of PW4 was one of those struck out for offending paragraph 45B of the first schedule to Electoral 2022, them not having been filed along with the petition. But the statement of PW4 struck out for being incompetent. Exhibits PCD 1, 2, and 3, forensic report tendered by him, were also struck out for being inadmissible. As stated earlier, the oral evidence of PW4 contained in his witness statement on oath and his report in Exhibit PCD 1, 2, 3 are the only evidence adduced by the petitioners to establish the allegation of overvoting. With the witness statement on oath of PW4 having been struck out for being incompetent, in the forensic report in Exhibits PCD 1, 2, and 3 also struck out for being inadmissible, there was no other evidence to substantiate the petitioner's allegation of overvoting. The petitioners have therefore failed to prove the allegation of overvoting. Issue 3 is also resolved against the petitioners. So based on the Based on all the foregoing, it is evident that the petitioners have failed to establish their allegations of corrupt practices and overvoting. In consequence, issue 3 is also resolved against the petitioners and some of the exponents. Issue 4 is whether from the evidence adduced by the petitioners, the petitioners have established that the second respondent was not duly elected a majority of lawful votes cast at the election. This issue deals with Section 134, Section 2 of the Constitution, the issue of 5% votes, Abuja. Whatever it is. Well, the resolution of this issue basically borders on the interpretation of Section 134, subsection 2B of the 1999 Constitution. The appropriate starting point for the resolution of this issue, therefore, is to reproduce, for ease of reference, Section 134(2)A and B of the Constitution of the Federal Republic of Nigeria 1999 as amended, the interpretation of which is in contention. It reads that a candidate for an election to the office of president shall be deemed to have been duly elected, where there being more than two candidates for the election. A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states in the Federation, the Federal Capital Territory. The contention is as to the interpretation to be accorded to paragraph B of subsection 2 of Section 134 quoted above. In particular, the contention is whether or not by the wordings in that paragraph, the candidate must, in addition to scoring not less than 1/4 of the votes cast in at least 2/3 of the states in the Federation, also score 1/4 of the votes cast in the Federal Capital Territory, Abuja, before he can be deemed to have been duly elected. In other words, whether in determining 2/3 of the states of the Federation in the Federal Capital is to be included and regarded as one of the states of the Federation, or the status is to be regarded as distinct from the other states of the Federation. Thus, that scoring 1/4 of votes in the FCC is a mandatory requirement for a candidate to be deemed duly elected as president. It is pertinent to state that unlike interpretation of statutes, the interpretation of the Constitution has its own guiding principle. We'll look at the principles as stated in Federal Republic of Nigeria versus Ganjua, reported in the electoral law report, where the Supreme Court recently reviewed budget cases on interpretation of the Constitution and outlined these principles, guiding principles follows. A. In interpreting the Constitution, which is the supreme law of the land, mere technical rules of interpretation of statutes will be avoided so as not to defeat the principles of government enshrined therein. Hence, a broader interpretation should be preferred unless there is something in the text or in the rest of the Constitution to indicate that a narrower interpretation will best carry out the sub-objects and purpose of the Constitution. B. All sections of the Constitution are to be construed together, not in isolation. C. Where the words are clear and unambiguous, the literal interpretation will be applied. Thus, according to words, their plain and grammatical meaning. D. Where there is ambiguity in any section, a holistic interpretation would be resorted to in order to arrive at the intention of its framers. E. Since the draft person is not known to be extravagant with words or provision, every section should be construed in such a manner as not to render other sections redundant or superfluous. If the words are ambiguous, the lawmaker's intention must be first in the Constitution itself, then in the other legislation and contemporary circumstances by resort to the administrative rule. B. The proper approach to the construction of the Constitution should be one of liberalism. It is improper to construe any of the provisions of the Constitution as to defeat the obvious ends which the Constitution was envisaged to achieve. In the case of Nafi Rabiu and the state, Bendel State was Attorney General Federation, Buhari, Obasanjo, Savannah Bang, Agilo, Abia State was AG Federation. In finding appropriate answer to this issue, I wish to observe first that, with all due respect to counsel for the petitioners, their interpretation of Section 134, subsection 2B of the Constitution, founded principally on a fixation that the word "and" appearing between the phrases has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states of the Federation. The Federal Capital Territory Abuja is completely fallacious, if not outrightly ludicrous. Even their recourse to the case of Abubakar and Yaradua does not help their argument because the JSC made it clear that a purposive rule of interpretation will not be appropriate where the intention of the lawmaker is clear, precise, and unequivocal. So much so that a person can say, yes, this is what the lawmaker has in mind. Thus, in the interpretation of the Constitution, the principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the purpose and scope of the provision. Global Excellence Communication Limited, Donald Duke, AG Bendel State, AG Federation, Saraki, Sky Bank PLC, Elim versus Bank. That this is the position is not at all open doubt. And Bronic Motors Limited versus Wema Bank Limited, Namani JC or Blessed Memory, speaking from the Apostle Court, confirmed it when, after a painstaking analysis of the cases on the point, set at pages 30 to 32, that quote, the Constitution is a living document, not just a statute, providing a framework for the governance of a country, not only for now, but for generations yet unborn. In construing it, undue regard must not be paid to merely technical rules. Otherwise, the objects of these provisions, as well as the intention of the framers of the Constitution, will be frustrated. As stated in Minister of Home Affairs versus Fisher, the constitutional requirement should not necessarily be construed in a manner according to rules which apply to acts of parliament. Although the manner of interpretation of constitutional instruments to give effect to the language used. Recognition should also be given to the character and origins of the instrument. Such an instrument should be treated as sui generis, calling for principle of interpretation of its own, suitable to its character, without necessary acceptance of all the presumptions that are relevant to legislation of private law. It has also been accepted by all our courts that a broad and liberal interpretation should prevail in interpreting the provisions of our Constitution, although one has constantly to bear in mind the object which provisions were intended to serve. Udo Udoma, JSC, very aptly stated this in Nafi Rabiu and the State, where the learned justice said, "My lords, it is my view that the approach of this court to the construction of the Constitution should be, and so it has been, one of liberalism, probably a variation of the theme of the general maxim, put tres magis valiat cum irea. I do not conceive it to be the duty of this court to construe any of the provisions of the Constitution as to defeat the obvious ends the Constitution was designed to serve, where another construction, equally in accordance with the words and sense of such provisions, serve to enforce, to protect such laws of court." Some years down the line, in Global Excellence Communications Limited versus Donald Duke, Bonogian JSC, later CJN, reiterated the relevant principle of the implementation of the Constitution, which is Lordship saying, among others, at page 19. Followed. The principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the scope and purpose of its provisions. The words of the Constitution are therefore not to be read with stultifying narrowness. Laws of court. All these were further followed by this court recently, the Federal Republic of Nigeria versus Muhammadu Maigari Dingyadi, in the following ways at the 33 of the court. One main guiding post is that the principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the purpose and scope of its provisions. The Global Excellence Communication, other cases. There is always a need for the fulfillment of the object and true intent of the Constitution. Therefore, the Constitution must always be construed in such a way that it protects what it sets out to protect and guide what it is meant to guide. The Adeleke or your State House or Assembly. In interpreting the Constitution it is the duty of the court to ensure the words of the Constitution preserve the intent of the Constitution. Every Constitution has a life and moving spirit within it, and it is this spirit that forms the reason d'etat of the Constitution, without which the Constitution will be a dead piece of document. The life and moving spirit of the Constitution of this country is captured in the preamble. It has been held that when a constitutional provision is interpreted, the cardinal principle is to look to the preamble to the Constitution as guiding star, and the directive principles of state policy as the book of interpretation, and that while the preamble embodies the hopes and aspirations of the people, the direct principles set out the proximate grounds in the governance of the country. Thakur and Union of India. In other words, in interpreting the words of Section 212(1)(a) of the 1999 Constitution as amended, the court should be guided by principles upon which the Constitution was established, rather than by direct operation or literal meaning of the words used in the provision, and where the literal meaning of the words used are not in consonance with the guiding principle. Literal interpretation must be jettisoned to another approach that accords with the guiding principles of the Constitution. The interpretation that would serve the interests of the Constitution and best carry out its objects, purpose must always part. Laws of court. Following these well-settled principles, our first port of call in unlocking the argument of the petitioners is the preamble to the 1999 Constitution and the direct principles of state policy contained therein, all of which embody the principles of the Constitution. The preamble to the 1999 Constitution loudly proclaims equality between citizens as its cornerstone, among others. Thus, we, the people of the Federal Republic of Nigeria, having firmly and solemnly resolved and to provide a constitution for the purpose of promoting the good government and welfare of all persons in our country on the principles of freedom, equality, and justice, and for the purpose of consolidating the unity of our people. State policy contained in Chapter 2 of the Constitution, which this court aptly described as the road to construction. The Federal Republic of Nigeria and Ingedi repeats this equality principle. Under its social objectives provision of that chapter in Section 17 thereof, it again proclaims that 1. The state social order is founded on ideals of freedom, equality, and justice. 2. In furtherance of the social order, every citizen shall have equality of rights, obligations, and opportunities before the law. Equality of rights in every citizen, as stated in this provision, cannot by any means be read to exclude equality of the weight and value of their votes. No, it includes it. Even more so, when the issue here is the right of every such citizen to elect with their votes their president, whose policies are supposed to and will affect all of them equally, regardless of which part of the country they reside or live. So even stopping here, the futility and hollowness in the argument of the petitioners that the votes of the voters in the FCT, Abuja, have more weight than other voters in the country, to the essence of their votes purportedly have a veto effect on other votes, is rendered bare. That notwithstanding, let us still proceed to consider, for whatever it is worth, their interpretation of Section 134, subsection 2b of the same 1999 Constitution, which incidentally centers around the word "and" that provision. In the first place, the settled position of the law is that in interpreting a constitutional provision of the court should be guided by the principles upon which the Constitution was established, rather than by the direct operation or literal meaning of the words used in the provision. And while the literal meaning of the words used are not in consonance with the guiding principles, literal interpretation must be jettisoned or another approach that accords with the guiding principles of the Constitution. It is quite clear that a calm reading of Section 134(2)b of the Constitution will leave no one in doubt
Many people
that the use of the word "and" by the framework between the words all states in the federation and the federal capital territory Abuja indicates that nothing more than that. The framers understand.
Gbogbo tí wọ́n ń ṣe yìí tó bá jẹ́ ìlú òyìnbó ni wọ́n ti ń ṣe nǹkan báyìí. kì í somi náà máa fún wọn o, àwọn kan máa wà ní kitchen tán máa dáná. Coffee, Lipton tea without milk, Lipton tea without milk, coffee náà máa fún wọn mu. Kò dìgbà téèyàn bá mu téèyàn bá mu gbáńlá tó fà á yó kẹ́rí ńlójú yóò fi dá. No, coffee, because tó bá mu coffee àmujù ẹnìyàn ò ní sùn. Gbogbo bó ṣe jókòó yẹn coffee náà máa fún wọn mu. Adájọ́ gan pẹ̀lú coffee ló máa mu. Wọ́n máa fún wọn ní coffee mu so that kí wọ́n má bàa ṣe kíni, kí wọ́n má bàa ṣe kíni, kán má bàa sùn. Kí wọ́n má bàa sùn, coffee náà máa fún wọn mu bọ́n ṣe wà yẹn. Coffee ni wọ́n máa mu. Wọ́n wá ń fún wọn lómi mu. Àwọn èèyàn ti ń sùn lọ lórí ìjókòó because ẹjọ́ tẹ̀ ń dá ẹ̀mọ̀ pé ó máa pẹ́. Coffee ló yẹ kẹ́ ẹ wá fáwọn èèyàn, ẹ wá gbómi síwájú wọn. Omi báwo? Alẹ́ ẹ̀mọ́ sí ní Nàìjíríà. Irú àwọn kéèsì tó máa ń pẹ́ báyìí, irú àwọn kéèsì ẹlẹ́jọ́ tó máa ń lọ gbọrọgbọrọ báyìí, tẹ́ mọ̀ pé kéèsì yẹn ń take time. Àwọn kéèsì tó máa ń take time bí eléyìí, tẹ́ ẹ rí bí eléyìí, coffee ni. Ẹ lè rí kán máa gbómi síwájú wọn, ọ̀tọ̀ láyé omi, ọ̀tọ̀ láyé coffee. Coffee náà máa fún wọn mú báyẹn so that kán má bàa sleep, so that they will not sleep. Ẹ rí gbogbo tí ń fall asleep. Mo rí kan tó yán lẹ́ẹ̀kan tó ní ọmọ àti lo wákàtí 6 ni mo mọ̀ kọ́kọ́ lò lálákọ̀ọ́kọ́. Wọ́n dẹ̀ ti bẹ̀rẹ̀ kémi tó pẹ́. Wọ́n ti lò tó 11 hours báyìí látago 10 àárọ̀. Bí náìsì ni ẹ wá wò tí náà látago 10 àárọ̀ Nàìjíríà. Torí wọ́n ti bẹ̀rẹ̀ ti pẹ́ gan. Torí tí mo fi kọ́kọ́ lo 6 hours lákọ̀ọ́kọ́, 6 hours lélẹ̀ tó stop yẹn. Tí mo padà gbé nísìn 6 hours yẹn wọ́n dẹ̀ ti bẹ̀rẹ̀ kó tó di pé mi bẹ̀rẹ̀. At least wọ́n á ti lò tó 8 to 9 hours lórí ìjókòó bọ́n ṣe wà yẹn. So coffee kán dẹ̀ máa fún wọn láwọn oúnjẹ bíi snacks, àwọn bóyá bíi bread and cheese. So that àwọn oúnjẹ kì í ṣe pé kán jókòó kán jẹ àmàlà àbí kán jókòó kán lọ jẹ kínní no. Àwọn nǹkan tó jẹ́ pé bóyá bíi nǹkan tó fast, bóyá bíi bread tán máa fi cheese sí nínú, àwọn slice bread yẹn tán máa po coffee sí, tán máa fi síwájú wọn so that wọ́n fi ní wíìkì. But gbogbo owó tán rí olè ni wọ́n fi ṣe làákàyè. Gbogbo tó yẹ kán ṣe kán láwọn tí ó mọ̀ sí gbogbo yẹn owó olè náà fi ń jà. Wọ́n ronú, wọ́n láwọn adviser gidi, àwọn adviser àwọn gangan wọ́n torí wọ́n bọ̀ because àwọn gangan kì í gbà bá wí. Sáwọn tí wọ́n gbà bá wí, wọ́n gbà bá wí.
In Ibori versus Uboru, where it was confirmed by this court that the Federal Capital Territory Abuja is to be treated like a state by virtue of Section 299 of the Constitution. If the Federal Capital Territory Abuja is to be treated like any other state, then it is not superior to or inferior to any other state in Nigeria. It is also my considered view that if the framers had wanted to make scoring 1/4 of votes cast in the Federal Capital Territory Abuja a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly spread the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. As expressly stated in Section 299 of the Constitution, for the purposes of fulfilling the requirements of Section 134, subsection 2B of the Constitution, for return of a presidential candidate as duly elected, the Federal Capital Territory Abuja is to be treated as one of these in the calculation of 2/3 of the states of federation. That if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the federation, FCT Abuja inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to score 25% of the votes cast in the Federal Capital Territory Abuja as the second respondent. Conclusion, I hold without any equivocation that in a presidential election, polling 1/4 or 25% of total votes cast in the Federal Capital Territory is not a separate precondition for a candidate to be deemed as duly elected under Section 134 of the Constitution. Consequently, issue 4 is also resolved against the petitioners and in favor of the respondents. It is right, Lord, that there is a rebuttable presumption of regularity with respect to election results, and it is for a petitioner who challenges that result to rebut that presumption credible evidence. This settled principle was stated by the Supreme Court in Buhari and Kanye, and Nyesom and Peter Side, others. Also in Udom Gabriel Emmanuel versus Mana Okon Umana and others. Those citations applied. I have also referred to Abubakar and Yaradua, Dewey versus Panic, Kiriko, Luma Hop versus Barrister Joseph. It is clearly evident that the petitioners have failed to discharge the burden of proof placed on them by law. They have failed to prove any of the three grounds contained in paragraph 20 of this petition. They have evidence to rebut the legal presumption of correctness as a result of presidential election held on 26 February 2023, led by the first respondent. Having resolved all issues,
wọn láwọn pọ̀ a sọ̀rọ̀ lẹ́ẹ̀kan bí pé ibi tẹ́ bá fẹ́ dá sí gbogbo tẹ́ ń kà ní ìsìn ibo la fẹ́ lọ gangan ká tètè sáré lọ ẹ ti wà ní tribunal láti bí oṣù mélòó kan lẹ ti wà court gbogbo nǹkan yìí náà dẹ̀ lẹ́ ń kà èmi ò rò pé ẹ kásẹ̀ tó máa tún kà lẹ́nìí èmi wò pé àkànṣèdájọ́ lásán ni pé ẹ ti ṣe gbogbo ilé sẹ́yìn àkàndé àdébí lé ní o àmẹ́ tó wọlé láì waste time rárá tábà àti ẹ̀ka àkà pín àkàn píkì pọ́ìntì nínú ẹ̀ á píkì pọ́ìntì bí á píkì pọ́ìntì bí á píkì pọ́ìntì bí kókókó kékèké tí ò ní gbàsìkò ṣùgbọ́n ẹ̀ píkì pọ́ìntì gbogbo eléyìí ti tẹ́lẹ̀ náà ẹ máa já ìgbésí ayé yín dànù ilé ayé yín lẹ̀ ń já dànù èmi mẹ́yìn tẹ̀ wà ń bẹ̀ ṣé bẹ́ẹ̀ ti ṣe voice note ká láti bí ọjọ́ mẹ́ta wípé tí wọ́n bá ti tí àwọn tó fẹ́ ṣe kínní ò bá ṣe kínní náà má ti lè gbé fún Tinubu o káwọn ọmọ máa jà lọ ẹ̀yin òpónú ayérada ẹ̀ kọ́ máa jà lọ ọmọ ẹni ìṣèdí bẹ́ẹ̀ bẹ̀rẹ̀ kọ́ fi sídìí ọmọ ẹlòmíì ṣé ọ̀dọ̀ tèmi wá náà ti ní kẹ̀sì ti bẹ́ẹ̀ bẹ̀rẹ̀ àbí kí n tèmi àti tiyín ẹbẹ́ yìí lẹ mọ̀jà tẹ́ ń jà ẹ́ ó ga fún yín o ẹ̀yin lẹ mọ̀jà tẹ́ ń jà o táwọn tó wà Nàìjíríà ṣe ẹ lè rí dátà orí ẹ mọ̀ dátà náà ń lò ẹ wòye dátà táwọn èèyàn jùlọ fún wákàtí 6 lọ́wọ́ fi wò torí Nàìjíríà lẹ fẹ́ kọ́gbọ́ kì í ṣe another country ara àbòsí tá à ń sọ fún yín pé kẹ́ mọ̀mọ̀ sí ara àbòsí tá à ń sọ nìyẹn ara àwọn àbòsí inú ara àwọn àbòsí wọ́n ti wà ní tribunal láti bí oṣù mélòó kan sìn náà ti wà ní tribunal court láti bí oṣù mélòó kan náà ti wà níbẹ̀ kí lábùrọ̀ tí wọ́n máa waste time máa waste energy àwọn èèyàn máa waste time àwọn èèyàn dànù pé kinní kan ó ṣe kinní jù kí ló ṣẹlẹ̀ gọ́gọ́ bẹ́ẹ̀ ni wọ́n máa disturb ayé àwọn èèyàn a ní ẹ ti wà ní tribunal láti jọ kán tó swear in Tinubu kán tó gbé wọlé ńlẹ̀ ti wà ń bẹ̀ ẹ dẹ̀ ti ń ṣe àti pé irú gbàtẹ́ bá fẹ́ ṣèdájọ́ kò yẹ kó tún máa gba àkókò iṣẹ́ wo lẹ pèsè fáwọn èèyàn tó wà ní Nàìjíríà tí wọ́n mọ̀ fi ra dátà ẹlẹ́fún wọn ní 8,000 naira àárí 8,000 naira oúnjẹ tẹ́ fún wọn kò wọ 2,000 naira àráìsì agolo kan ìlọ́nà ń ta 150 naira indomie tí bá kà ó lè ju 10 lọ wọ́n dẹ̀ bá ń fi epo àwọn epo inú ọ̀rá kékeré tomato náà fi wọ́n epo fún yín tó tẹ̀ wọ́ 8,000 naira gan. Peter Obi lose petition to cast Tinubu election over $460,000 forfeiture is US drug case proceeding still going on, live streaming on Arise, okay, and our YouTube. Ó ga o, wọ́n ní Obi ti lùsì Olusi case. Olusi Nigeria Election Court 10 witness statement from 13 Labour Party witness. The dismissal was granted. Nigeria Election Court strike our APC shoot against PDP. Against Peter Obi, Labour Party member. The issue member of political party is an internal party affair. Sẹ́ẹ̀rì mọ̀ wípé gbogbo eléyìí tán ṣe yìí, èmi ò tiẹ̀ rí sí, wọn ò rí sí, because I think pé ó yẹ kí gbogbo ẹ ti mọ bí ó ṣe mọ ọ lọ. Eléyìí láòdù gan o, àmọ́ ibi tá à ń lọ báyìí lẹ́nu. 45 minutes ago, Obi lose petition to crash to Gwas Tinubu election over $460,000 lórí drug case. All lose àwọn náà wà ń bẹ́ẹ̀. Àwọn náà wà ń bẹ́ẹ̀. Èmi kúkú waste energy mi, èmi bí mo ṣe wà mo mọ ibi tọ́rọ̀ ń lọ. Àákàn mọ́ bá yín gbé wá ni, àwa mọ ibi tó ń lọ torí pé ẹ mọ̀ pé àwọn tẹ́ ń sọ àwọn go ready láti bọ́. So people are not ready because they are looking for someone they will face the war so that they will kill the war, they will kill the person, and after they will come back and say àwa ṣèkínní kan ńgbọ̀n bá pẹ́ ni ńgbẹ́ ni ẹ bá jagun fún wọn tó fẹ́ yà kógun tẹ́ni ẹ bá ń dá lọ wọ́n tún máa attack ẹ̀, wọ́n máa weak emotional ẹ̀, wọ́n máa weak power ẹ̀, wọ́n máa weak energy ẹ̀, wọ́n máa bring everything down from the person that is fighting for them. Everywhere, every around corner tí ẹnìyẹn ti lè gbà láti jà pé kán lè bọ́ ni wọ́n máa gbógun tẹ́nìyẹn. Tẹ́nìyẹn bá wá ṣe tí ò kú mọ́ wọn lọ́wọ́ tó bá tẹ̀ tó wá rọ̀nà àbáyọ láti sọ pé bóyá ó jẹ̀jẹ̀ yẹn fún wọn tán tó jà tán òun ni wọ́n tún padà fi ṣèrúbọ lé wọn, wọ́n tún fi ṣèrúbọ. Àwọn ò wá rí ibi ìgbà ẹni wọ́n mọ̀ wípé ó ní ìgbéraga, ìgbà ẹni wọ́n mọ̀ pé ẹnu rẹ̀ ti ṣe jù, wọ́n wá mú ẹ̀mí ẹ̀ lọ, àwọn á wá bọ́ sórí ipò náà. Wọ́n wá bọ́ sórí ipò náà. Kò sí nǹkan tó lé anybody tó bá ready láti ṣe tó dáa, kò sí kíni tó wà nú ẹ̀. Àníkà àti kí ìlú dáa. Amẹ́ríkà tẹ́ ń fò lọ, gbogbo ibi tẹ́ ń fò lọ, ṣé yóò mọ̀ pé owó lẹ̀ ń rí wọ́n ń fún wọn lówó ni. Ẹ wo olú wọn bó ṣe rí náà, ẹ̀yin ń lọbẹ̀, wọ́n ń fún wọn lówó. Ẹ wo orílẹ̀-èdè wọn bó ṣe dáa, torílẹ̀-èdè wọn ò bá dáa ẹ̀yin ò ní máa lọbẹ̀. Ní sọ pé ẹ̀ ń lọ, ẹ̀ ń sáré lọ, ẹ̀ lọ invest. Ẹ wo iye ilé tí ẹ ní sí ẹ̀yìn odi lẹ́yìn ẹ̀yìn politician jákujàku. Ẹ mọ iye ilé wọ́n ní ilé sẹ́yìn odi o. Ìwọ dìdìrín dín róbó tó ń jà fún wọn. Iṣẹ́ bíríkì ló ń ṣe wọ́n 1,000 naira. Tábà ti pín 1,000 naira, wọn ò lè fún ju 1,000 naira lọ. Because tó bá yẹ pé wọ́n jẹ́yàn gidi ni ibi tẹ́ ti wá góòlù. Tẹ́ mọ̀ pé iṣẹ́ burúkú ni iṣẹ́ tán ṣe mẹ́ẹ̀tán wà, wọn ò ní mọ̀ pé wọ́n 1,000 fún yín lójúmọ́. Ìyẹn mi pé 1,000 lẹ́ ń gbà lójúmọ́ fún dátà tó fi wá ń bú mi lábẹ́ péèjì mi. Dátà mo fi bá rẹ́ lómi màmá rí pé á lòun ṣiṣẹ́ ní LTC. Ó pọ̀ burúkú sky kìíníkà LTC materials. Ẹ ó ṣe jẹ́ gbogbo ẹ̀yin Nàìjíríà lẹ́ ń ṣiṣẹ́ ní materials láwọn tó máa ń kọ́mẹ́ǹtì lábẹ́ mi. Kìíníkan materials LTC, kìíníkan materials LTC, sky materials LTC làwọn ti ṣiṣẹ́. Ìyẹn mi pé gúrùpù kan ni yín tẹ̀ ń sí kiri lórí péjì. Wọ́n máa ti fún yín báyìí 1,000 naira wá ní ẹlọ́gbọ̀n sòṣì. Ẹ ń lọnu wọ́rùn yá yín o. Ọ̀rọ̀ ọ̀run mi bó ṣe ń dún. Mo jókòó síbí látàrí òtòrí tiẹ̀ ọ̀bọ̀ ń bẹ́ ọ̀hún sòṣì bí ẹran aṣẹ́wó. Bìkọ́ torí pé rẹ́dì láti gbára yín kò nínú wàhálà. Ẹ̀yin gò ṣetán láti bọ́. Bìkọ́ ẹni tó bá ń jà fún yín lọ̀tá yín. Ọ̀rẹ́ ìlú ni ọ̀tá ìlú. Ẹni bá ń jà fún yín òun lọ̀tá àti yín àbẹ̀rẹ̀ Ọlọ́run. Ẹni bá ń jà fún yín lọ̀tá yín. Ẹni bá dúndò pé kọ́nà yín kó lè là kẹ́ lè nísinmi ẹni gbẹ́nu sọ́hùn máa jà fún rẹ. Nàìjíríà la wà. Nàìjíríà la wà. That's why tó jẹ́ pé mi fẹ́ like àwọn tó jẹ́ Nàìjíríà yẹn kí n máa bá wọn sọ̀rọ̀ torí àwọn ọ̀rọ̀ burúkú kan wà lẹ́nu tó máa ń múnú rún mi. Wọ́n máa sọ pé ìwọ náà ta ló ní ó wá jà? Ta ló ní ó wá jà fún wa? Wọ́n dẹ̀ wà ńbẹ̀, wọ́n dẹ̀ máa wá tọrọ báyìí. Wọ́n máa wá tọrọ, wọ́n máa tọrọ. Wọ́n máa wá nu inbox yín, owó yìí ni wọ́n máa tọrọ. Wọ́n ṣe ń tọrọ owó náà máa tọrọ gbá. Ọmọ àwọn ẹsẹ̀ lè ṣèrànlọ́wọ́. Ọmọ àwọn ṣe kinní kan, àwọn ò tí jẹun látàárọ̀. Àwọn ò tí ṣe kinní kan látàárọ̀. Àwọn ò tí ṣe gbá, àwọn ò tí ṣàwọ̀. Wọ́n máa tọrọ fine bara. And they are not ready. They are not ready to sacrifice for anything. Ẹgbọ́n tí bàbá tí mo play jọ yẹn sọ, ó láwọn ready láti kú tàwọn torí ẹ̀yin ikú tí yín ò tí yá. Ẹ̀yin ò dẹ̀ ẹ̀yin bẹ̀rù kú torí ẹ̀ ń sá fún kú. Ẹ̀ ń sá pé kíkú mọ́ pa yín. So that àwọn tó dẹ̀ ti mọ irú ẹ̀ńtẹ́ jẹ́ pé ikú ni ẹ bẹ̀rù bọ́n. Àwọn tó rántí mọ gbogbo yín nànà ọ̀tún yín. Wọ́n ti mọ gbogbo ẹ̀. Wọ́n ti mọ̀ wípé bẹ́ẹ̀ lọ wájú bẹ́ẹ̀ lẹ́yìn. Bẹ́ẹ̀ lẹ̀tún bẹ́ẹ̀ lòsì. Wọ́n mọ̀ pé tó bá ti lè fìbọn halẹ̀ fún yín ẹ̀ ń sá lọ nìyẹn. Tó bá ti lè halẹ̀ ìbọn mọ́ yín tán halẹ̀ mọ́ yín ẹ ti túlẹ̀. APM lulẹ̀ lórí ẹ̀sùn tó pè tako èsì ìbò ààrẹ Tinubu. Ilé ẹjọ́ ní aláyọnusọ ni ó parí o. BBC kí ló dé? Ṣé bó ṣe pẹ̀lú ṣé kóòtù sọ pé aláyọnusọ ni? Ẹ wo àwọn kókó ẹ̀sùn tí olùdíje ààrẹ fẹ́gbẹ́ olóṣèlú PMP pé tako ààrẹ Bọ́lá Tinubu àti àwọn ìdí tí ilé ẹjọ́ fi gbé olùdíje náà wọlé lórí ẹjọ́ tó ń pè. Wọ́n lẹ́lẹ́yọnusọ ni ẹ. Wọ́n ní sọ bá lẹ́yọ ké ó pa mí lẹ́rìn. Ilé ẹjọ́ ilé ẹjọ́ kò tẹ́mi lọ́rùn gbé ìdájọ́ kalẹ̀ lórí ẹ̀hónú ìbò ààrẹ tẹ́gbẹ́ olóṣèlú APM pè. Ilé ẹjọ́ kò tẹ́mi lọ́rùn gbé ìdájọ́ lẹ̀. Ẹ máa gbé lẹ̀. Bí ìgbìmọ̀ tó ń gbọ́ ẹ̀hónú ìbò ààrẹ ní ilé ẹjọ́ kẹtẹ́milọ́rùn tó wà ní Àbújá ṣe ń gbé ìdájọ́ rẹ̀ kalẹ̀ lórí ẹ̀sùn tí àwọn olùdíje fún ipò ààrẹ lórí èsì ìbò ààrẹ tó kọjá. Ẹ jẹ́ ń sọ fún yín, èmi ní dára mi láàmú torí Nàìjíríà mo ti sọ láti bẹ̀rẹ̀. Mo kọ síbẹ̀ yẹn fún ẹ̀yin tèmi. Mo ní do you think? Are you think? Do you think? Are you thinkology? Wípé kóòtù yẹn ó máa do the right thing. Èmi dára mi láàmú o. Èmi dára mi láàmú o. Ẹ̀yin lẹ̀yin mọ ara yín tẹ̀ ń dà láàmú. Ẹ̀rí mi ní kóòtù tribunal. Tribunal dájọ́ kan lẹ́ni. Ó fẹ́ fọ́ Obi. Ó fẹ́ fọ́ Àtíkù. Ó fẹ́ gbọmọ ti ráyè tí mo mọ̀ káwọn náà ní Nàìjíríà. Nígbà bá fẹ́ kó ṣẹlẹ̀ ní ó ṣẹlẹ̀. Àwọn náà ń pàṣẹ, ó ti wà lórí ipò àṣẹ. Everything ni wọ́n ti tò kíákíá. Owó wà ńlẹ̀. Owó náà fi ń so gbogbo. Wọ́n ti gbàgbé pé owó nǹkan míì wà tówó ò lè ṣe. Nǹkan míì náà sì wà tówó lè ṣe. Torí owó ẹlòmíà máa ní owó ò ra ọmọ irọ́ lọ́pa owó ra ọmọ o. Because ọba lówó ó ra ọmọ. Bó bá rówó ó nìkẹ́ni ó mú ọmọ kan wá fọ́mọ ọ̀dọ̀ tó lọ fẹ́ gbà tó sì ní ó bọ́ ṣe sọ̀rọ̀ géètì. Yóò sì bọ́ ṣe sọ̀rọ̀ géètì ó sì promise rẹ̀ lówó ńlá. Yóò sì bẹ inú ilé rẹ̀ ní ó mọ̀ pé ìwọ ló mọ̀ bọ̀, ìwọ ló mọ̀ fún lóúnjẹ, ìwọ ló mọ̀ ṣe gbogbo rẹ̀ fún. Tó bá dẹ̀ ti bímọ ó ra gbọmọ lọ́wọ́ rẹ̀. Ó ra sẹ́ndì ò sí ẹ̀yìn odi. Ẹ ra sẹ́ndì ẹ̀ sílùú òyìnbó pẹ̀lú ìwọ̀n owó tó fún pé o lè lọ ṣe business náà. Bó bá sì wọ o lè lọ rè náà bó ṣe wù ọ́. O ti tó owó kan, owó rẹ̀ mí. Owó nìkan, ẹ̀mí nìkan lówó òdò. Torí tí ọlọ́jọ́ bá dé kò sí tó lè fowó ṣe o. Kò sí tó lè fowó ṣe o. Ṣùgbọ́n owó sì tún ra ẹ̀mí. Ṣẹ́ni pé ó lọ bá owó tún ra ẹ̀mí. Báyìí ni mo ti sọ pé owó tún ra ẹ̀mí ńgbà mí. Torí pé tó bá wò pé Nàìjíríà tó wò yẹn tí wọ́n bá rí nírí wípé owó ò ra ẹ̀mí. Téèyàn bá wà lórí dùbúlẹ̀ tó lágbára. Tó bá jẹ́ hospital Nàìjíríà náà gbé ẹ sí owó ò lè ra ẹ̀mí. But owó yẹn bá wà wọ́n fly rẹ̀ out of Nigeria. owó ra ẹ̀mí níbẹ̀ yẹn torí wọ́n ṣiṣẹ́ wọn perfectly owó tí ẹni kó o ti ṣe wọ́n ò dùn ẹ̀mí rẹ̀ ọwọ́ alẹ́ di pé létà ó dà láàbò ara bóyá nǹkan kó dínkù ọ̀sà àlàáfíà ó pè é àbáwọn kọ́kọ́ ni wọ́n ń lo tó máa ń jẹun tó pé tó máa ń jẹun mi ìmọ̀ ọkọ̀ tó ń pè wọ́n ẹ dáríjì mi o ọlọ́run mi fi yọ̀ wọ́n mo kàn sọ ni o tó bá jẹ́ orílẹ̀-èdè nàìjíríà nírú nǹkan yẹn ti ṣẹlẹ̀ sí wọn lè yé tán máa ń fi kátítà báyìí síbi àyà wọn tó jẹ́ pé páìpù ni ó máa wà ní wọ́n máa ti páìpù yẹn bọ̀ láti bẹ̀yẹ lọ síbi ọ̀nà fún wọn so tó bá ti ń jẹun kó sà máa rí pé nǹkan wá láti ẹnu wọn inú páìpù yẹn lóúnjẹ yẹn máa ń rọ sí inú kíní kátà yẹn ni oúnjẹ yẹn máa ń rọ sí tíì kì í dẹ̀ sókèlè bíi tíì náà máa mu ló máa ń rọ sí ikùn wọn kíní kan tó wà ń bẹ̀ so bó bá jẹ́ nàìjíríà ní owó ò lè rà irú wọn ò kù ṣùgbọ́n irú àwọn eléyìí owó ra ẹ̀mí wọn so mùgbọ́n tọ́lọ́run bá sọ pé kò tí ó tásìkò owó ò lè rà torí òyìnbó ń kú aláwọ̀ dúdú ń kú aláwọ̀ dúdú everyday everybody ń lọ ń pa yín so ọlọ́run ní pé kó jẹ́ kí ọjọ́ tiwa kó jìnnà tí a ká má kúkú ọ̀wọ̀ ká má kú dànù lórí ọ̀rọ̀ tí mo ń sọ lẹ́ẹ̀kan lórí ìdájọ́ kan tó dá lẹ́ẹ̀kan pé wọ́n ń da ìgboro rú sẹ́yìn náà rí pé ẹ da ìgboro rú ẹ ìṣàgbèrò ẹ fún everybody ní freedom of speech òun lẹ́yìn kan náà ti ń ṣe yìí torí pé mo ń gbé láìfù oríṣiríṣi ni mo rí tẹ́ǹsẹ̀ ló sì sálẹ̀ kí ló kàn yín torí pé ọmọ Yorùbá sì ní wọ yìí ọmọ Yorùbá ni ẹ dákun mo fẹ́ béèrè o látijọ́ tí mo ti délé ayé látijọ́ tí wọ́n ti bí mi sáyé tí ìyá mi àti bàbá mi ti bí mi ò jàǹfààní olóṣèlú kankan bó tilẹ̀ pé fámílì ìyá mi wọ́n jẹ́ politician ní ìjàǹfààní wọn o èmi parọ́ o lè jẹun nínú ilé wọn o ṣùgbọ́n wọn ń ṣiṣẹ́ àṣekára so mi ò jàǹfààní wọn wọ́n lè jẹ́ lóṣèlú tó wọ́n kàn máa nà mí nígbà náà wọ́n máa nà mí nígbà náà àwọn ọmọ wọn máa nà mí wọ́n máa ní tí ìbá kí n bá ti fi rí àwọn báyìí kí wọ́n máa kúnlẹ̀ láti ẹnu géètì kí wọ́n máa kún ojú tẹ́ni ọmọ ológo rí o tí bọ̀dá yẹn bá dé báyìí mo forúkọ bọ̀ ọ́ láṣìírí gbogbo ìkà tó ṣe fún mi nígbà tí mo wà ń kékeré tí mo ń gbé lọ́dọ̀ bàbá yín wọ́n mọ̀ ní táwọn bá ti yọ lẹ́nu géètì báyìí kí wọ́n máa kúnlẹ̀ kí n bá ti gbọ́ pé géètì sí báyìí tí n bá rí wípé géètì sí tí n bá ti rí páwọn ni kí n sáré wá kúnlẹ̀ pàdé àwọn kí n máa rákòrò bọ̀ ìjọ tí mi ìbá mọ̀ bóyá mò ń ṣiṣẹ́ lọ́wọ́ nínú ilé tí mi mọ̀ pọ́n dé tọkàn dédé yọ sọ́dọ̀ ìyá wọn ìgbà wọn ẹ̀sìn ni o ẹ̀sìn níyà wọn o tí n bá Christian ni o tí n bá dédé tí n bá ń ṣiṣẹ́ nǹkan lọ́wọ́ bóyá tí mi mọ̀ tàbí mo wà nínú ilé tí mi mọ̀ pọ́n lóde tó bá yẹ dé bá mi nínú ilé lórí ìjókòó tó jẹ́ pé mi mọ̀ pọ́n níbọ̀ tí mi ti máa rákòrò wá bá á nà mí láìṣẹ̀ láìrò á dẹ̀ máa nà mí bọ̀dá Yẹmí ìwọ ni mò ń bá wí mi tiẹ̀ pé Yẹmí gan ló ń kọ ẹ mi ò jẹ́ lábẹ́ ẹ̀ náà ó ṣe ká fún mi náà Yẹmí ló kọ ẹ Yẹmí Àìná mo dárúkọ ẹ ìtàkà tó ṣe fún mi nígbà kékeré ó ti pọ̀ jù Yẹmí Àìná ó máa ń nà mí gan a máa ní kí wọ́n máa rákòrò wọ́n máa ń nà mí ní ìsìn náà bí ọrẹ wọ́n máa nà mí ṣé tó bá tẹ̀lé mi gan sọ̀rọ̀ ní ti yes ma tó bá rí mi ní ìsìn gan sọ̀rọ̀ tiẹ̀ lè fọwọ́ kàn mí torí tiẹ̀ ní gbẹ́gbẹ́ tán ò ní fẹ́ ṣe bẹ́ẹ̀ ò ní fẹ́ fatagé gomoga ìyá rẹ̀ ò ní gbà mí lẹ́lẹ̀ ìyá rẹ̀ ṣe jẹ́ ìsìn tó kò ní gbà mí lẹ̀ Ọlọ́run fọ̀run kẹ́yà yín ìyá wọn ti lọ bàbá yín náà ti lọ bàbá wọn náà ò ní sọ̀rọ̀ wọ́n mọ̀ ọ̀nà mi wọ́n mọ̀ ọ̀nà mi wọ́n mọ̀ ọ̀nà mi gan o wọ́n nà mí gan wọ́n nà mí mi ìjàǹfààní wọn bó ṣe máa nà mí tó mi ìjàǹfààní rẹ̀ ṣebí téèyàn bá tiẹ̀ nà yẹn yóò jẹ ìjàǹfààní ẹni tí ń nà yẹn ìjàǹfààní wọn kàn máa ń lù ní kékeré wọn á ní mo stọ́bọ̀ wọn máa ní mi ìwà kí àwọn ojú èèyàn rí gan o akàn gborúkọ lérí nípa jẹ́ fámílì Àfọlábí kí lẹ ṣe fún mi ẹ máa lù mí ṣeré ni lẹ́yìn ìbúra Láńre ló máa rán mi ní bíà lọ́dọ̀ wọ́sọ Láńre ò nà mí bá Láńre ò kí nà mí ìyẹn Láńre Àfọlábí mínísítà yín tó lọ lọ́sùn education ni àbẹ̀wò ló ń jẹ Láńre Àfọlábí ìyẹn máa rán mi ní bíà o lè máa mọ̀ mí mọ́ èmi ló máa rán bíà lọ́dọ̀ ọ̀wọ́sọ tíkùn rẹ̀ yọ báyìí tó rán mi lọ́dọ̀ tíjà tó ń pè ní ọ̀wọ́sọ níwájú ilé yín kí n lọ bá ra bíà wá ó láìkì bíà kù ó ní lọ rà wá ṣùgbọ́n Yẹmí máa ń lù mí kú, ó máa ń ná mi gan, mi lè láìkì, wọ́n fìyà jẹ mí gan, wọ́n nà mí jọ́kan gbogbo ara mi dé ẹ̀bó, mo wá jókòó sínú ilé, mo wá ń dá sunkún, mo wá ń dá ronú. Kò dá kéèyàn máa fọmọ sọ́dọ̀ èèyàn, kò dá kéèyàn máa fọmọ sọ́dọ̀ èèyàn. Sẹ́lẹ̀ àwọn tó máa ń fọmọ sọ́dọ̀ èèyàn, àwọn ọmọ ojú wọn máa ń rí gan, wọ́n máa rí gan. Ẹ̀yin tiwa àríbó àmọ́ tó ṣẹlẹ̀ o, àmọ́ bí tán bá dé wọ́n ti pajú ẹ̀ ní ṣe ló ń kú lẹ́ẹ̀mẹ́wàá. Ẹ jẹ́ ká bá yín wá news lọ, ká wo news. So ẹ jẹ́ káwọn èèyàn ní freedom of speech in any way. Ẹ jẹ́ káwọn èèyàn ní freedom of speech nínú gbogbo nǹkan táwọn èèyàn bá ṣe. Ẹ jẹ́ káwọn èèyàn máa ní freedom láti lè sọ̀rọ̀. Bẹ́ẹ̀ bá tiẹ̀ jẹ́ wípé ẹ fẹ́ ṣèdájọ́ àbí bóyá ẹ máa ná, ẹ jẹ́ káwọn èèyàn ní freedom. Ẹ má bá force àwọn èèyàn pé gbogbo nǹkan tẹ́
Both Brothers Limited was Niger Construction Company Limited and another. That principle cannot by any means override the fair hearing trial provision of Section 36 of the 1999 Constitution, which also underpins the rationale for exchange practice regime that emphasizes front-loading of processes. Such dishonorable practice can only be likened to the unlawful boxing tactic of hitting one's opponent below the belt or from behind, which in the sport of boxing is penalized promptly with deduction of points. It cannot be different here. The said statistician's report, which is exhibits PAH1, PAH2, PAH3, and PAH4 in this proceeding must be and is hereby discountenanced. That conclusion should make the resolution of this issue of imprecision of the petition fairly easy. I shall nevertheless want to exercise caution and still consider the paragraphs of the petition attacked by first respondent,
Ẹ jẹ́ mi lórí Tẹ́ni Ọmọlógo blog.
And in the petition. That regard, I am satisfied that paragraph 92 of the petition, where the petitioners allege wrongful calculation of polling unit results in various local governments of Sokoto State is lacking in particulars of the particular polling units affected and so liable to be struck out. Paragraphs 93 and 94 of the petition, where petitioners allege that first respondent officials failed to properly fill election forms in Kano State, I think, sufficiently meets the requirements of paragraph 41D of the first schedule to the Electoral Act 2022. Paragraph 95 of the petition, where the petitioners allege that results in unspecified polling units in some local government areas of Kogi State were, quote, manipulated through and by the inflation of the second respondent's votes and depletion of the petitioner's votes, end quote, is in my opinion bad for vagueness, not only as to the polling units where the alleged manipulation occurred, but also as to the actual lawful votes of petitioners and second respondent allegedly depleted and inflated respectively. The need to plead exact figures of votes affected by the alleged manipulation becomes even more crucial, in my opinion, when account is taken of paragraph 15 of the first schedule of the Electoral Act, stating that, and I quote, this is what that paragraph 15 says, when a petitioner claims a seat alleging that he had the highest number of valid votes cast at the election, which is what the petitioners are doing here, the party defending the election or return shall set out clearly in its reply particulars of the votes, if any, which he objects to, and the reasons for his objection against such votes, showing how he intends to prove at the hearing that under this provision, requiring them to, quote, give particulars of the 97 of the petition, in my opinion, are matters of proof at the hearing, even more so as petitioners have stated. In those two paragraphs, that the disruption of elections in Adavi and local government area of Kogi State by 82nd and respondents left the video recording which the petitioners will lead evidence in proof. Paragraph 98 of the petition, where petitioners allege that elections in 10 polling units were disrupted and there were no results from the said polling units, end quote, is bad for vagueness and specificity, insofar as it does not specify the affected 10 polling units, therefore also liable to be struck out. I'm also of the opinion that paragraphs 99 and 100 of the petition, also attacked by first respondent, has to do more with proof, which is a matter for the substantive hearing, especially as infractions complained of in them were again, according to petitioners, captured in a video recording which they promised to rely at the trial. Paragraph 101 of the petition, where the petitioner simply complained of failure of first respondents officials to properly fill election material, seems to me sufficient pleading. Paragraph 102 of the petition, where the petitioner simply alleged that infractions occurred in polling units unidentified in various local government areas of Kogi State, and what these failures enabled results of the polling units in the led the LGAs to be manipulated through and by the inflation of second respondents' votes, and the depletion of petitioners' votes is bad and vague as the particulars of the specific polling units and votes of petitioners and respondents affected by the said manipulation of inflation and deflation. It fails to meet both the requirements of clear pleading of facts of the petition and paragraph 15 of the first schedule of the Electoral Act aforesaid. In fact, the following dictum of the lead judgment of Tabai GSC in Belgora and Ahmed clearly says so, my lord. We have already produced all these things in CA03, and we don't intend to read. In any case, you get it and you see it. Also, PDP versus INEC. For the same reasons, I am also of the opinion that paragraphs 103 of the petition, where the petitioner simply avoid generally that, quote, as respondent wrongly entered incorrect results to state is bad insofar as the polling units in Borno State affected by the incorrect results are not stated. I am, however, of the view that paragraphs 104, 105, and 106 of the petition sufficiently clear necessary facts to elicit appropriate response from respondents, even more so as paragraphs 104 merely alleged bypass by first respondents of previous elections. The presidential election in Benue State, while paragraphs 105 and 106 simply stated the petitioner's ground that second respondent was not elected by majority of lawful votes. With respect to paragraph 104 of the petition, first respondent complains that the petitioner there contended that the entire results of the presidential election were wrong. Yet they did not plead the results they perceived to be correct, so it is also vague pleading. I am of the view that that complaint is better considered while considering the merits of the petition. That is even more so as it appears to us that paragraph 104 seems averred to by petitioners to meet the provisions of paragraph 4 sub 1 of the first schedule of the Electoral Act that requires them to state in their petition, among other, the scores of the candidates in the election. To that extent, paragraph 104 cannot be faulted by application at this stage, let alone ought to be struck out in limine. Paragraph 105, 109, 110, 11, 12, and 113 of the petition merely pleaded facts as to whether second respondent, who by first respondent's own showing did not poll up to 25 of the total votes of Federal Capital Territory, was properly returned by first respondent having regards to the provisions of section 134 E of the 1999 Constitution of the Federal Republic of Nigeria and other relevant statutes, is therefore in order. I am afraid paragraph 114 of the petition 115 and 116, and paragraph 4, where they said purported results from 6,418 polling units have and indicate zero accreditation, and paragraph 118, where they have that critically, paragraph 118 and 119 are all bad for lack of particulars of necessary facts. As for the statistician's report, again referenced by them for the said particulars, I hereby reconfirm my earlier finding and conclusion on it. Paragraph 120 of the petition is not challenged by first respondents, so I shall overlook it, at least for now. Petitioners, paragraph 121 of the petition allege that first respondents, presiding officers of polling units failed to properly fill and countersign alterations in election forms, including forms EC, 8B, and blah, 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 but they did not mention the polling units. What local government and state said infractions took place. They simply reference the same statistician's report. This paragraph is bad for imprecision and so also liable to be struck out. Paragraph 122 to 125 of the petition are not challenged by respondents, so I shall skip them. In paragraph 126 of the petition, the petitioners complain that all over Nigeria, the manifest cases of overvoting. Total of the affected polling units in the various states are set out in the statistician's report, and relied upon by the petitioners. This pleading is also, This pleading is also bad for vagueness. My earlier position on the statistician's report, referenced by the petitioners, is also reaffirmed. Paragraph 127 and 128 of the petition are not challenged by first respondents, so they are also skipped. I do not share the view of first respondent that paragraphs 129, 130, that's INEC, and paragraphs 129, 130, 131, and 132 of the petition are bad for lack of imprecision. Petitioners in those paragraphs carefully pleaded the specific polling units and numbers of votes therein that they claim were affected by the cancellation of elections complained by them. I am, however, of the opinion that the second complaint of first respondent against paragraph 129 of the petition, that is also the failure to join Honorable Adejo, chairman of Onoma Boro local government of Kogi State, accused by them of having led thugs at gunpoint to force electoral officers in the polling units in Onoma Boro local government to declare concluded elections in the said units cancelled. It's well made. The petitioner's response that not only was no relief claimed by them against Honorable Adejo, did not even participate, quote unquote, in the election, neither was he returned, so it's not a petition contemplated by Section 132 of the Electoral Act to be joined to an election petition. It's not a valid response. Section 133 of the Electoral Act only deals with the issue of which contestant of an election ought to be joined in an election petition by a co-contestant. It has nothing to do with the issue of joining of third parties against whom allegations of electoral infraction are made by practitioners, as in this case. Such petitions must be joined to the petition if the court is not to be exposed to the risk of infringing their fundamental right to fair hearing guaranteed by the Constitution. It is also of no moment that no relief was claimed against such persons in the petition. What is important is that allegations of electoral malpractice, which will require the court to make findings, including condemnation of the alleged conduct, where necessary, are made in the petition. Support for that position can be found in Nwankwo and Yaradua, where Muntaka Kumasi JSC, after reproducing the provisions of the then newly enacted Section 1441, sub 2 of the Electoral Act, which is now Section 1332 of the Electoral Act 2022, and confirming that that provision had done away with the whole regime of the Electoral Act that required petitioners to join all relevant electoral officers of INEC that conducted an impugned election. In addition to INEC, said, this is what his lordship said, that unless the conduct of a petitioner who is not an agent, or the conduct of a party who is not an agent of the commission is in issue, it will then be necessary to join such party as a necessary party to the petition in order to afford such party their hearing, end quote. As regards the consequence of failure to join such necessary parties of the petition itself, his lordship Kumasi again said as follows. However, where such a party is not made a party, it will not result into the whole petition being struck out. And the particular allegation against such party is liable to be struck out, end quote. That is the fate of paragraph 129 of the petition, where allegations of electoral malpractice were made by the petitioners against Honorable Adejo, yet he was not cited in the petition. Incidentally, this is also one of the main reasons the Supreme Court gave in dismissing the appeal of the petitioners. In the Odo State governorship case of Eitai Ojegede and another, versus INEC, where allegations were made by the petitioners in that case against the then National Caretaker Committee chairman of the present head respondent APC, Governor Mai Malabuni of Yobe State, yet he was not joined to the petition by the petitioners. Paragraph 129 of the petition must therefore suffer striking out. For the same reason, paragraph 133 of the petition, where similar allegations of an alleged gun-toting Governor Yahaya Bello of Kogi State didn't talk to compel cancellation of concluded elections, polling stations were made, yet he was not joined to the petition, must also be struck out. Paragraph 135 and 136 of the petition were not challenged by first respondents, so they are hereby skipped. I consider this a convenient point to consider paragraphs 137 and 142 of the petition, which learned senior counsel to INEC further complained was also bad for non-joiner. Counsel's argument this time was that the petitioners were also seeking in those two paragraphs to avoid the entire results of the presidential election in Lagos and Kano states, as declared by INEC, where Mr. Peter Obi of the Labour Party and Rabiu Musa Kwankwaso of the New Nigeria Post Party scored the majority of lawful votes. Yet Peter Obi of the Labour Party and Rabiu Musa Kwankwaso were not joined to the petition, so those paragraphs were also bad and liable to be struck out. I consider this argument misconceived. In fact, it seems to overlook Section 134 sub 4 of the 1999 Constitution, stating expressly that, and I quote, for the purposes of an election to the office of president, the whole of the federation shall be regarded as one constituency, end quote. That is the position as it relates to a presidential election. Percentages of votes polled by presidential candidates in any of the 36 states of the federation or even the federal capital territory only become of consequence when the issue verges on whether the candidate also satisfy the provisions of Section 131B and 2 of the 1999 Constitution, as amended, requiring him to poll 25% of votes as in at least two-thirds of the 36 states and the federal capital territory. Outside of that, how many votes a presidential candidate polled in any of the states of the country is of little significance in an election petition challenging return in a multi-party presidential election. Certainly has no bearing on the question of who an aggrieved party challenging a presidential election return should join to his petition among the candidates that contested the election with him. As Section 133 of the Electoral Act, the only other candidate in the election the petitioner can properly join the petition. The person returned as the winner of the election. If further on this, the cases of Buhari and another versus Yusuf, Yusuf versus Obasanjo and 50 others, Obasanjo and Yusuf versus others, particularly Buhari, and another versus Yusuf, where it was said by, and I quote, by the Supreme Court, where it was said that, and I quote, an unsuccessful candidate in an election cannot be made a party to an election petition against his will, end quote. We also do not agree with first respondent that paragraphs 141, 141, and 142 of the petition were vague or imprecise. I do not, sorry. I am rather of the view that facts necessary to elicit an appropriate response from the respondents of the electoral infractions complained of by the petitioners have been pleaded in those paragraphs. I, however, agree with first respondent that paragraph 142 of the petition, where the petitioner simply complained that first respondent deliberately entered wrong results for 22 name states herein, paragraph 44, where they averred that there were discrepancies on very large scale at the various local governments, various levels of recording and collation of results, particularly between the polling units and the ward polling centers, without specifying the said polling units and ward collation centers, where these said quote and unquote large scale discrepancies took place. And paragraph 144, where petitioners gave notice that they would rely on their same flawed statisticians' report, among other documents they did not front load, are bad and liable to be struck out for vagueness. Paragraph 142 of the petition, where petitioners simply stated as ground of their petition that the petitioners aver that the correspondent was at the time of the election not qualified to contest the election, not having constitutional threshold, quote and unquote, that is all they said. It's also imprecise and vague as it gives no particulars of any of the several qualifying and disqualifying factors set out in sections 131 and 137 of the Constitution. Main purpose of pleadings as further fortified by paragraph 4 sub 1b of the first schedule of the Electoral Act, we repeat, is to properly and clearly inform the adverse party of the case is coming to meet, so that it can respond appropriately to it. That is fair hearing. That requirement of the law does not permit parties to keep their cards face down, as petitioners did in paragraph 146 of their petition, when they simply aver generally that second respondent was not qualified to contest the 25th February presidential election, without revealing in what form he was not qualified or disqualified for the election. That paragraph of the petition falls far short of the requirements of paragraph 41b of the first schedule of the Electoral Act, and so liable to be and must be struck out. Conclusion on issue 1 of first respondent, the sum total of all the foregoing is that paragraphs 129 and 133 of the petition are liable to be struck out for non-joinder, to which Mrs. Adejo and Governor Yahaya Bello of Kogi State accused the petition of committing electoral malpractices. Paragraphs 92, 95, 98, 121, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack particulars, and so fall short of the requirements of paragraph 41b. They are all therefore ordered struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 100, 111, 112, 113, 114, 115, 16, 118, 19, 120, 122, 125, 130, 134, 138, 139, 140. On the other hand, are in order and properly heeded. Now, issue 2 of first respondent in this same application reads whether having regard to the mandatory provisions of paragraph 41b of the first schedule of the Electoral Act, the reasonable course of action has been disclosed in respect of grounds of the petition contained in paragraphs A, B, and D of the petition to warrant further or any adjudication on same. Counsel on behalf of first respondent this time anchored the arguments principally on the grounds on which petitioners founded their petition. Counsel reproduced paragraphs 16a, b, and c of the petition where the petitioners alleged and let them out. The next reference, section 134 of the Electoral Act, stating that an election may be questioned on, among others, that the election was invalid by reason of corrupt practices, and argue that this provision, that is section 134, has a proviso in section 135(1). So the fact that an election shall not be liable to be invalidated by reason of non-compliance with provisions of the Act, if it appears to the election tribunal occurred that the election was conducted substantially, compliance with the principles of the Act and the non-compliance would have substantially affect the result of the election. Relying on the cases of Ojukwu and Yaradua and Yusuf as a judge, Senate submitted that for petitioners to sustain their ground of corrupt practice and non-compliance with the election with the provisions of the Act, they are required to not only plead the fact of non-compliance, but further assert positively in the petition and prove that the non-compliance and corrupt practice complained of substantially affected the result of the election. To properly do that, they argued petitioners must plead and show how many votes were affected by the irregularities and the deduction of such votes would void none of second respondent as the winner of the election. That not only the petitioners not assert in their petition that non-compliance complained of substantially affected the election, they did not also plead the votes or polling units affected by non-compliance to enable this court form an opinion on that non-compliance and corrupt practices complained of substantially affected result, or that second respondent polled majority of lawful votes in the election and so what to be returned. Without those facts in the petition, the petitioner's counsel submitted have simply blown quote unquote muted trumpet and their petition lifeless and failed to disclose a substantial cause of action, so it is liable to be dismissed. Resolution of issue 2. This issue does not, in my view, deserve any serious consideration. The reason being that petitioners expressly stated in paragraph 17 of their petition that, quote, petitioners are bad that the election was not conducted in accordance with provisions of the Electoral Act and other relevant laws, and that the non-compliance substantially affected the result of the election. In that, the second respondent ought not to have been declared and returned as the winner of the election. That sufficiently answers the question of first respondent. Issues 2 and 3 and 4, first respondent first allocate application. Answer to first respondent, the issues 3 and 4, which they also argue together, basically relied on their contentions in issue 2 of the lifelessness of the petition. Submit that the petition as by reason of the alleged submission in the petition identified above had become academic and considered abuse of process of course, so this court is robbed of jurisdiction. Retain it. This combined issue is founded on issue 2, and since issue 2 has been determined against first respondent, issues 3 and 4 perish with it, and so are hereby resolved against first respondent. Now I come to second respondent similar application seeking dismissal of paragraphs 14 and 15, 19 to 81. For this application, letter counsel second respondent simply said that the sole issue for determination thus was that in view of the provision of paragraphs 14(1)(d) of the first schedule to the relevant Electoral Act and relevant judicial decisions, whether paragraphs 14 and 15, 19 to 81, 87 to 104, and 108 of the petition are not liable to be struck out. We set out the arguments, both of them. Said in the course of determining first respondent's application on the same issue of vagueness and precision in the complaints, I dwelt extensively on the rationale for exchange of pleadings, generally and particularly in election particulars as further set out by the lawmaker. I hereby adopt all those pronouncements. Same exercise are also considered and pronounced on the same complaints of vagueness, lack of particulars, generic and imprecision. Of the complaints of the petition's paragraphs 92 to 1% of the petition, also made by the second respondent here, I there determined, we said what we this thing, and said, I abide by those findings. I shall therefore simply focus on paragraphs 14 to 19 and 1.7 to 150, and the few paragraphs between paragraphs 92 to 1% of the petition omitted by first respondent that determined complaints of second respondent of whether petitioners' complaints to those paragraphs were vague, imprecise, and generic. And now start that exercise. Now to reference to what I said earlier, and which I hereby reconfirm on the invalidity of the statistician's report relied on by the petitioners for particulars of the amendments in the petition. I am of the opinion that paragraphs 14 to 15 of the petition, where the petitioners specifically complained only about correctness of the contents of INEC forms, are so clear as to the issue raised and so not vague. Paragraph 16 of the petition are not attacked by first respondent and so are also skipped. We also do not find paragraph 20 to 20 of the petition where the we do not also find paragraphs 20 to 20 of the petition where the petitioners complain that first respondent did not keep his earlier promise of electronic transmission of election results to his IREF portal in real time when it returned this in vague. We, however, find vague, imprecise, and falling far short of the requirements. I, however, find vague, imprecise, and falling far short of the requirements of paragraphs 4(1)(d) and 15 of the first schedule of the Electoral Act 2022, the amendments in paragraph 22 of the petition, where the petitioners complain that the result of the election as announced by INEC does not represent lawful votes, and that lawful votes cast for them were massively deducted from their polls. Those paragraphs ought to contain the lawful votes of the petitioners that were alleged, quote, massively deducted, as well as those alleged to have been allocated to second respondent by INEC. Defined properly and sufficiently clear paragraphs 24 down to 27 of the petition. However, find vague, imprecise, and lacking particulars paragraphs 82 to 86 of the petition, where the complainants complained that permanent voters' cards collected in unit results where elections were collected or did not hold across the country is above 1,000, is above 1,810,206, which is the margin of lead between first respondent, first petitioner, and second respondent. Consequently, the turn of second respondent was hasty, premature, and wrongful. This pleading not to contain the precise number of permanent voters' cards alleged collected with polling units, which by petitioner's contention would have closed the margin of lead between first petitioner and second respondent to make the latter's return unlawful. Without that information, the complaint is difficult to understand and respond properly to, let alone resolve. Paragraphs 87 to 90, where the petitioners complain of corrupt practices in conduct of the election, which practices they complain took the form, among others, of manipulation by second respondent through deliberate suppression and discounting of votes. It's vague insofar as the polling units where the said corrupt practices took place are not stated. Paragraphs 92 to 97 of petition, less paragraphs 135 and 36, also complained of by first, second respondent as vague, imprecise, and generic, have been dealt with by us while considering first respondent's petition on the same issue. We have adopted our findings in that application, resolving the complaints of second respondent in this application. As for paragraphs 135 and 136 of the petition, we have the view that paragraph 135, where petitioners complain of manipulation of election in Lagos State by first respondent, resulting in depletion of their votes and inflation of second respondents' votes, is vague in the absence of pleading of the number of votes so depleted and inflated. In respect of paragraph 136 of the petition, even the petitioners again complained, even the petitioners again complained that the votes returned by first respondent for Obi Akwa and Port Harcourt local areas of Rivers State did not reflect the actual votes. If that has pressed the SL votes, actual votes scored in the said local government areas, or even those updated to IRF by INEC and so liable to be voided, no correct quote unquote figures of the actual votes cast as reflected in the IRF were pleaded. So it is also bad for vagueness and imprecision and therefore liable to be struck out. Sum total of the foregoing are complaints of vagueness, imprecision, and genericness of garments, all by second respondent against the petitioner, only made out as regards paragraphs 23, 82 to 86, 89 to 91, 92 to 95, 98, 121, 124, 126, 129, 133, 135, 136, 147, 144, and 146 of the petition. Accordingly, those paragraphs are hereby struck out, while the remaining paragraphs of the petition are deemed in order and pass the vagueness test of paragraph 41D of the first schedule of the Electoral Act. Pronouncing the said paragraphs of the petition bad for vagueness and liable to be struck out, we are not unmindful of the argument of petitioners that second respondent's remedy lies in an application for further particulars and not striking out. We are, however, of the petition that application for particulars is only one of several options open to second respondents, who in any case is not under any obligation to help petitioners make out their case against you by asking for particulars of the generic and nebulous complaints. That is also the point that was made by Fabi EGS in PDP versus INEC, when his lordship said at page 524 that, and I quote, the application for further particulars or the like is merely a shield in the hand of a party who so desires, and not a sword to be used by a party whose pleading grossly inadequate, insufficient, or devoid of necessary particulars. Decision in Olawekpo versus Saraki, cited by legal counsel on both sides, is in point. It's not the duty of a respondent to groom a petitioner on how to draft his petition, end quote. It is also quite revealing, if not even reassuring, we must say, that this argument of the petitioners of duty of second respondents to ask for further particulars, that's their main argument, in their petition rather than asking for striking out the particulars, was also rejected by Muntaka GSC while delivering lead judgment in PDP versus INEC in 2012. Even as the same argument had found favor with his lordship, that's Muntaka, 2 years earlier in his contribution in Nwankwo versus Yaradua. His lordship in the latter case of PDP versus INEC endorsed the stand of trial tribunal in that case, at paragraph 12, sub 5 of the first schedule to the Electoral Act, same as paragraph 12.5 of the present Electoral Act. Okay. Permitting respondents to apply to strike out a petition did not exist in the 2000 Electoral Act, in force at the time Nwankwo and Yaradua was decided, and that made all the difference. Regarding the further argument of second respondent, petitioners complained that first respondent did not observe his own promises to transmit election results to either portal in real time, was caught and made comatose by section 134 of the Electoral Act, stating Electoral Act. I think it is neater and even safer to defy it to the main argument for determination on its merits, especially since that contention is also one of the main complaints of the petitioners in the petition itself. That is what case law decides. Advice is sorry. See again one Kwan Yaradua citation. Third respondent's application on the same issue of vagueness of paragraphs. Our own application, that is the third respondent this time. That in his own application of 8th May, third respondent, like first and second respondents, also plead us to strike out all of paragraph 17 to 146 of the petition. On the same grounds of vagueness, imprecision, blah, 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 and failure to join the Sadijo and Governor Yahya Bello of Ogun State, case whom allegations of electoral infraction were made. Additionally, it's also complained that petitioners have amendments in paragraphs 19, stated them, and 45 of the petition are all pre-election matters which occurred after the petition and outside the jurisdiction of this constituting as an election petition.